Testing. All right. Good morning. To start off today, we're in a different room and different mics. So please always make sure you're speaking into the microphone loudly and clearly. And make sure that when you are not speaking, please turn off your microphone because of the bandwidth or whatever that we have with respect to our system today. So, good morning again. I'm Chair of the United States Sentencing Commission, Carlton W. Reeves, and I welcome you all to this hearing. I thank each of you for joining us, whether you're in this room or whether you're attending via live stream. I have the honor of opening this hearing with my fellow commissioners. To my left, we have Vice Chair Claire Murray, Vice Chair Laura Mate, and Commissioner Candace Wong. To my right, we have Vice Chair Luis Felipe Restrepo, Commissioner Claria Horn-Boone, and Commissioner John Gleason. We're very pleased to be joined by Scott Meisler, who was recently appointed by Attorney General Garland to serve as the ex officio commissioner representing the Department of Justice. I know for those who have been regular attendees, you've seen Jonathan Wroblewski in that spot. We have someone else now. Commissioner Meisler serves as Deputy Chief of the Appellate Section in the Criminal Division of the United States Department of Justice. Previously, he was a trial attorney in the Appellate Section, which he joined in 2009. He has also served in several other roles in the Department of Justice, as an assistant to the Solicitor General, as an assistant special counsel in the Office of Special Counsel Robert S. Mueller III, and as a member of the Criminal Division's National Cryptocurrency Enforcement Team. Commissioner Meisler, I want to thank you for being willing to serve on this commission, and I know it is a sacrifice for you given all your other duties. Please know how much I appreciate that sacrifice, as do our fellow commissioners. Speaking of those commissioners, I want to thank all of them for their extensive contributions, their spirit of collaboration, and their dedication to our work. I'm honored to be sitting among these group of esteemed colleagues. We're also joined by commission employees, some of whom are in this room, most of whom are not. They have done the research. They have coded every pre-sentence report, every judgment and commitment order, every statement of reason. They have drafted the policies. They have set up this room, and they have done so much else to make this hearing possible. On behalf of the commissioners and the public, I thank all of our agency staff for the amazing work you do every single day. Earlier this year, the commission voted to amend the guidelines in ways that reduce sentences for future defendants. The purpose of today's hearing is to help the commission decide whether those amendments should be applied retroactively. The question, in other words, is this: should current sentences, some imposed weeks, months, or even years ago, be adjusted to reflect the rules that will govern future sentences? In the run-up to this hearing, we received extensive comments on the question from the public. We received hundreds of comments from judges, lawyers, religious leaders, doctors, professors, advocates, victims, families, and incarcerated people. We're so grateful to everyone who commented. The comments we received are posted on our website, www.usssc.gov www.ussc.gov. You can also find the videos and transcripts of the hearings we conducted on these amendments. I encourage the members of the public to read these comments and watch our prior hearings. Remember, when you speak to the commission, you will be heard. Today, the comments we have already received will be buttressed by testimony from a distinguished group of individuals. To all who are speaking with us today, I promise that your extensive journeys and preparations will be worth it. I appreciate you being before us in such trying times. When you speak to the commission, you will be heard, and you will be read, too, as your testimony is available and will be available for the public to access on our website. I want to take this opportunity to thank each of you. Those who are testifying today have other, what I call day jobs. Your personal sacrifices in accepting what I call these other duties as assigned, these tasks are deeply appreciated. Not just your testimony, but your work for the public, your work on our working groups, and generally the things that you do every day. We thank you, and our criminal justice system is made better because of your commitment, your work, and your sacrifices. Panelists, you will each have 5 minutes to speak. We have read your written submissions. Your time will begin when this light turns green. It'll turn green. You have 1 minute left when it turns yellow, and no time left when it turns red. If I cut you off, please understand that I'm not being rude. Rude is not part of my nature, okay? I'm not being rude, but we have so much to cover today and a limited time to hear everyone. For our audio system to work, again, you will need to speak closely into the microphones. I hope I've been doing that. When all panelists have finished speaking, commissioners may ask you questions, and I'm certain they will do so. Thank you for joining us, and I look forward to a very productive hearing. Now, with that, I'd like to introduce our first group of panelists who will present the criminal law practitioner's perspective on retroactivity for our amendment on acquitted conduct. We should know that the Department of Justice has always participated and has always had persons on each of the panels that we will have. Today is a different day, however. The Department of Justice, the U.S. Attorney who was scheduled to be here cannot be here because of events that occurred over the weekend. So we apologize on the Department of Justice's behalf, but again, other duties as assigned have required that that person not be here. His testimony is made a part of this record. His opening statement will be made a part of the record. You can, persons who will review, you can review the statement at the close of this hearing. It is submitted. The members of the commission have reviewed it, have read it, and are deeply grateful to the Department of Justice for submitting the testimony. So now, that means, though, that the first up, we have Adil Bashir, an attorney with the Federal Public and Community Defenders Sentencing Resource Council. He will be offering the appellate and trial litigation assistance to defenders nationwide. He previously served as an assistant federal public defender and senior appellate attorney for the Office of the Federal Public Defender for the Middle District of Florida. And then we'll have Mr. Patrick F. Nash, who serves as the Vice Chair of the United States Sentencing Commission's Practitioners Advisory Group. Mr. Nash represented defendants in criminal matters for 2 decades before forming Nash Marshall PLLC in 2012. His practice focuses on complex criminal defense with particular emphasis on federal matters. I now turn to Mr. Bashir. We're ready, sir, when you are.
Good morning. Good morning, Honorable Chair Reeves, Vice Chairs, and Commissioners. Thank you for inviting me to share the defender's views about making the 2824 acquitted conduct amendment retroactive.
Could you adjust your mic and speak directly to well, can you all hear the back? We need to make sure you can hear it.
Is that better? Thank you. All right. Well, thank you once again. And as Chair Reeves mentioned, I served for over a decade as an assistant federal public defender in the Middle District of Florida. And both in that role and in my current role as with the Sentencing Resource Council, I've worked on all aspects of the past 4 major retroactive guidelines amendments. Now, the practice of acquitted conduct sentencing has been described as perverse, defying common sense, and fundamentally unfair by jurists, politicians, and academics alike. And while the chorus of criticism spans many arenas, they all coalesce around one unifying theme, and that's that acquitted conduct sentencing subverts the jury's historic role in our system. Now, take, for example, the Supreme Court's opinions from this past term. In both criminal and civil cases like Jansky, McElrath, and Erlinger, the court over and over again emphasizes the jury's historic role as the gatekeepers of ensuring the court's power to punish and take away a person's liberty. Now, the purpose of this amendment, the acquitted conduct amendment, to restore respect for the jury's verdict and uphold the integrity of our legal system, strongly favors retroactive application. Consider the sentencing reform's legislative history. Now, the SRA's Senate report, for instance, provides if there is a major downward adjustment in the guidelines because of a change in community views of an offense, the Commission may conclude that the adjustment apply to persons already serving sentences. This amendment exemplifies such a shift, with a groundswell in recent years of community views calling for the end to the practice of acquitted conduct sentencing, culminating with the Supreme Court calling for reform, and this Commission very commendably answering that call. My biggest message here today concerns the feasibility of implementing this amendment retroactively. If what's passed is prologue, we know that predictions that this amendment will be difficult to administer or will undermine the purposes of sentencing are at best vastly overstated. Rather, experience teaches us that with each passing round of retroactivity, we have fewer filings than anticipated, increased collaboration among stakeholders, and limited strain on courts' dockets. For instance, the process in my former district, the Middle District of Florida, involves handling retroactivity efficiently by setting up procedures well before the amendment's effective date, prioritizing case filings, and working with stakeholders to build consensus. And when disputes arise, as they inevitably do, we aim to resolve them without protracted hearings. Based on my decade-plus experience as a defender, and from the vantage point I now have in my role with the Sentencing Resource Council and interacting with defenders all across the country, I anticipate a similar successful process for acquitted conduct amendment. In fact, I've already seen defenders laying the groundwork should the Commission vote to make this amendment retroactive, taking steps as trying to identify potentially eligible individual, fielding questions from clients and from attorneys, and developing strategies to ensure a smooth process for filing. Now, I want to be clear about this. There will no doubt be some instances where there's some nuanced cases that we have to roll up our sleeves and figure out whether and to what extent acquitted conduct impacted the guideline range. But this is really no fundamentally different than what we've done for past amendments, and it's work that we'll be doing for this amendment prospectively. And if anything, we know that in the 3582C2 context, with a limited fixed record and dependent upon showing a change in the guideline range, litigating these cases here provides a solid foundation for applying the case law prospectively. But even so, the simple fact remains the fact that we might have a small fraction of nuanced cases from an already small universe. That's people that went to trial and received a partial acquittal is no reason to avoid retroactivity. And I'll also stress there have been some concerns raised about whether retroactivity will upset finality or create disparities or undermine public safety. And I'm sure we'll talk more about that today. But I want to stress that these concerns derive from habeas case law that deal with the finality of convictions and not with sentences. And they're also ungrounded in empirical support. So I see that with my time concluding, I want to stress that this commission has a chance to write the last chapter of a three-part trilogy, one that began with a chorus of criticism about acquitted conduct sentencing, crescendoing with calls to end that practice, and culminating with the way this commission changing the way acquitted conduct is used at sentencing as we knew it. And when the defenders urge this commission to write retroactivity into this final chapter of acquitted conduct sentencing to end the tale as we knew it. Thank you, and I look forward to answering your questions.
Thank you, Mr. Bashir. Oh, thank you, Mr. Bashir. Mr. Nash.
Yes, thank you, Chairman. And good morning. My name is Patrick Nash, and I'm here to speak on behalf of the 17-member Practitioners Advisory Group. I've been practicing federal criminal defense as a CJA panel attorney for over 30 years, and my fellow PAG members are also longtime federal criminal defense attorneys. And I'm here to convey the PAG's unanimous opinion that the acquitted conduct amendment be applied retroactively. Our group's opinion was based primarily on ideas of preservation of the jury system and of fundamental fairness. And so in my opening remarks, I will likewise focus on those two ideals. We all know the story of Deonta McClinton. Every circuit has people like Deonta. In my circuit, the Sixth Circuit, one such person is Roger Clayton White. Roger was convicted of bank robbery. He was found not guilty of 3 counts that related to the discharge of a firearm. His bank robbery guidelines for the count of conviction were 78 to 97 months, 6.5 to 8 years. In the words of the Sixth Circuit, the trial court instead calculated the guidelines, quote, as though the jury had found White guilty. The sentence imposed by the district court was 264 months, 22 years. Roger served about 10.5 years of that sentence, and then he died before completing the remainder of the sentence, and he was 51 years old. In Deonta's and Roger's cases, they relied upon their constitutional right to a trial by jury. Their jurors were properly selected from a representative cross-section of the community. The United States government used its resources to convince those fair jurors, and the jurors unanimously decided that the correct verdict was not guilty. And then the trial judge sentenced them as though the jury had found them guilty. Most people who are not familiar with the nuances of the various burdens of proof would say that we are simply, when we proceed in this fashion, we are simply discarding our jury system. And certainly the defendants and their families involved in those cases feel like that their jury trials were meaningless. It is our position that we can't have these perceptions, and instead we must preserve and support our jury trial system as the best system in the world for determining the correct outcome in criminal cases. Now, cases like Deonta's and Rogers and other cases like theirs were the catalyst for the changes that this commission has decided to make. These types of cases were the catalysts for the acquitted conduct amendment. The plights of people like Deonta should not now be forgotten. Fairness requires that they should have the opportunity for a potential sentence reduction. It's too late for Roger, but it's not too late for Deonta. On occasion, an amendment is passed that is rooted firmly in fairness. Crack cocaine disparity amendments were such an occasion. The acquitted conduct amendment is another such occasion. It is the position of the PAG that these types of fairness amendments are the most deserving of retroactive application. Thank you, Chair.
Thank you, Mr. Nash. I now turn to my colleagues. Who wishes to be first?
You want me to go first?
Yeah.
The new guy?
Jump
New guy?
in, jump in.
Yeah.
Mr. Meisel.
Well,
Yes.
thank you both for being here. Like the chair said, I really appreciate the work you do and the insights you're bringing to this proceeding. I was going to go to Mr. Nash because he had mentioned the case of Mr. McClinton. I think you called him the catalyst for some of the changes in this amendment. I just wanted to get my understanding of how you think the amendment would apply to him, because I guess my understanding of his case is a bit different, right? This is one where, as I understand it, the district judge who presided over the trial found at sentencing that holding Mr. McClinton accountable for the murder would not be inconsistent with the jury's verdict, because the jury was only charged with deciding his guilt on a robbery count, a separate robbery count, and the use of a firearm during that robbery count. And the judge said the jury may well have concluded that he did the murder, but didn't do the robbery. And the gun count, the use of the firearm count, was tied to that robbery. So I'm just trying to figure out how the commission, or I should say how the amendment would apply in a 3582C proceeding, even if made retroactive. Do you think Mr. McClinton would actually be eligible for relief under this amendment?
So I think that Mr. McClinton could very well be eligible, and I think that this is one of the cases that, with the help of defense counsel, can be sorted out by the trial judge. The point of the amendment, obviously, is a correct calculation of the guidelines without use of any acquitted conduct. And so in Mr. McClinton's case and other cases like that, the task at hand will be to determine what aspects of the jury's verdict were taken into account in setting the guidelines. It may well turn out, as you suggest, that the conclusion is that none of those facts were part of the setting of the guidelines. But the point that PAG wants to make is that he should have that opportunity to have his defense counsel analyze that issue, frame the issue for the court, and have the trial court reassess exactly what or what not was determined in setting the guidelines.
Thank you.
DC Bird.
Thanks so much to both of you for being here. Am I close enough to the mic? Maybe a little closer. Okay. How's that? I'm wondering if you can help us with numbers a little bit. This is a little bit different than the last round of retroactivity we did, because last round we had very precise, I mean, they may have been off in some ways, but the numbers that were presented to us were very precise in terms of likely number of impacted defendants, likely change in anticipated change in sentence, et cetera. And here our numbers are just a lot rougher. So we have kind of an outer bounds estimate of how many people are, of how many defendants went to trial and were acquitted of at least one count. But obviously that's an outer bound, right? Because not everyone who went to trial and was acquitted of one count was sentenced based on any of the conduct that underlay one of those counts. And we also don't have a good sense, because we don't know the right universe, we don't have a good sense of the delta in terms of sentencing, but you're both there kind of on the ground. And without asking for you for any like computations, what's your kind of just sense of how many people who go to trial and are acquitted of a count end up with some increase in their sentence based on some conduct that plausibly underlay an acquittal? And what's your sense of what portion of the cases it's a sort of marginal increase, and what portion are kind of like, we've been calling them tail wags the dog cases, like the McClinton case, without knowing all the facts of McClinton?
So I think there's two things I would stress with that, because and this goes to the point about kind of laying the groundwork and trying to get a sense of how feasible or how manageable applying this amendment retroactively would be. So the first thing I would say is the universe is quite small, And when we're looking at the Commission's impact report and also organically speaking to defenders across the country, in my current position, we have a working group that contact with defenders across the country, but in the districts where we have the highest number of cases where individuals went to trial and also received acquittals. There's only a handful of cases, probably in each district, where we have this scenario as you were describing, where not only did you go to trial, you have an acquittal, but there was an impact on the guideline range. So you don't have something affirmatively in the record where the court is sentencing outside of the guideline range. So when we're talking about that universe, I think the first point there is that it's significantly smaller than past amendments. Now, on the flip side, when we're talking about the impact, I think the impact here is actually going to be quite significant comparative to past amendments. And the reason for that is as both a trial attorney and an appellate attorney in best practices, when you have a scenario in which your guideline range is being dramatically increased by acquitted conduct sentencing, those are the times where you're not only making that objection, that's where you have the strongest shock to the conscience. So you have cross-references that are going from relatively low guideline ranges to potentially murder guideline range, or et cetera, or you have drug computations that are dramatically increasing from specific offense characteristics or otherwise. Where it's smaller and in the margins, as a practical matter and speaking to defenders, what you end up seeing more often than not is some way at sentencing where judges and courts, and they're adept at figuring out what the proper sentencing range is commensurate to a guideline range. And when we're talking about 3582 and a reduction to that reduced guideline range, the cases that we're going to be seeing is where you have a larger delta. So the factors that this commission should be looking at really in terms of feasibility, we're talking about a small universe of people that could have a potentially large impact. And one final just bookend that I would say from last year that I think is significant and in previous years, while we did have large numbers of precise calculation, the 80,000 range of potentially impacted persons, if you look at the amount of motions that have actually been filed, is significantly less. And that's been consistent throughout all the rounds of retroactivity, because when you get to the ground and you actually start evaluating eligibility and who could potentially benefit, the number of motions that go forward tend to be less. So if we're taking that as a predictive measure, we're talking about an even smaller number here. And I would just echo my colleagues' comments that this is precisely the group of people that we want to give that opportunity to walk through the door to have a benefit from this amendment.
Thank you. I don't want to cut off any commissioner, please. I understand the red light is on, but if you have any question, please. VC Mate?
Thank you. Thank you both for being here this morning. I appreciate it. I have a question about guiding principles on retroactivity decisions, acquitted conduct, and I guess all of the ones we're talking about today and that have been considered in the past and the future. The comments we received identified a number of principles that could or should guide our decisions on retroactivity. Almost all of the commenters noted the factors that are listed in 1B 1.10. And this is a question for both of you. But I noticed in the defenders there was an identifying several factors from the Sentencing Reform Act and saying that those had been considerations in the past, things like promulgating policies that are fair, promoting respect for the law, avoiding unwarranted disparities, and accounting for BOP capacity. I'm curious about your thoughts on the factors in 1B 1.10 and those general directives to the Commission in our Enabling Act and how all of those factors should be guiding our decisions on retroactivity.
Well, thank you for that question, because I think it actually goes to the heart of why this amendment really should be made retroactive. So as far as guiding principles, yes, absolutely, 1B 1.10 and the factors that this commission uses are your baseline guiding principles for how the commission decides whether to make an amendment retroactive. But I think the best way that I like to think about it is these are, when we're talking about these additional factors of the Sentencing Reform Act and principles of fairness or otherwise, they're not necessary conditions, but they're certainly historically sufficient conditions, and they're ones that really push us over the edge. And when we're balancing the two together and really looking at these and understanding the factors of purpose and impact, when we're talking about amendments like in the past, 750 comes to mind, of one that's a clear instance of redressing past disparate sentencing and ones that have had racially disparate impact. We have a similar situation here, and when we have that combination together, that not only takes us to our rote factors that the court should be looking, or this commission should be looking at, but also these additional conditions that really just put the cherry on top and bring it together, that when we have these additional conditions, that it makes the decision that much easier.
And I'll just conclude here. Obviously, the red light's on here, but Vice Chair Mate, I think it's a good point to talk about. You know, we've got the specifically set out guideline ways to analyze potential retroactivity, and then you bring in these other sort of overarching ideas of fairness, and I think that dovetails with the idea that, you know, when Congress set up the system, they specifically provided for a retroactivity possibilities for each change that lowers the guidelines. It's statutory, so Congress is specifically contemplating an evolving and an improving system, not a static system, not one where finality rules the day. And so our suggestion to the commission would be, when you have an appropriate amendment that under all of those factors is appropriate for retroactive application, sort of blanket adherence to ideas of finality is really inconsistent with the way the system was set up and what Congress envisioned in the system. They wanted this commission to improve the guidelines and for it to be a living, breathing set of guidelines, and I think by applying amendments like this retroactively, you're fulfilling what Congress envisioned.
Thank you.
Commissioner Boone, and then go.
Thank you. And I think my question is more a general question for either one of you, but I think it dovetails nicely off of the previous question. The Criminal Law Committee noted in its public comment that the commission has made only 30 of its over or about roughly 800 amendments retroactive over the years. I haven't checked that number with our data folks, but I presume it's correct, or you know, certainly I think everyone would agree that retroactivity in the past has been the rare exception rather than the rule. The Criminal Law Committee cautioned that, you know, reflexively or routinely giving retroactive effect to amendments risks undermining some of the principles of finality, certainty, deterrence. In the CLC's words, they have, quote, concerns about the cumulative effect on the system of what may be seen as a trend toward applying amendments retroactively, even where the amendment does not rectify a fundamental inequity or unfairness. And so the federal defender and the Practitioners Advisory Group advocates that all the amendments, all 4 of these amendments, be made retroactive, like the ones last year. Is the federal defender seeking a change in the way the commission has analyzed retroactivity over the last few decades? So that's just sort of a general question that I have as far as this trend that was noted by the CLC. And then how do you respond to these concerns? What are the limiting principles under 1B 1.10?
Sure. I'll take those in both parts, and really lends itself to two responses. So the first, are we seeking a change? And to pick up on my colleague's comments about how this system is really designed to be an evolving guidelines and the principles that are in 994 and 1B 1.10. Rather than seeking a change, what we are advocating for, and I think is the correct application of the principles that underlie not only the guidelines changes but retroactivity. As famously as always, how statistics can sometimes be misleading. 30 of 800 may seem like a rarity, but we have a number of amendments that don't impact the guideline range or are perfunctory in other ways. We happen to be in a period now where this commission is recognizing some fundamental changes to the guidelines that are correcting and bringing us towards a fairer, more just system. And that is precisely what 994 and what this commission's guidelines intended for. The very purpose of us being here today is to determine whether guidelines amendments that impact the guideline range should be made retroactive. As to the second point about the limiting principles, I think it's really important to stress, and especially CLC, and I know some of the other commentary, often cite case law talking about finality and deterrence. And when they do so, they typically cite from Teague and other habeas cases. And it's a really important distinction, and I think quite telling as well, that we are in just a fundamentally different world than we're talking about habeas case law and upsetting the finality of convictions versus the 3582C2 world and 994 when we're talking about the finality of sentences, and sentences that, as we were just speaking about earlier, that the commission is recognizing past guideline ranges were fundamentally unfair and produced disparate results. So I think it would be a little unfair or misguided, if I can use that word, to rely on the principles of habeas case law when we're just in an entirely different universe here. And if we actually are following the principles of retroactivity that the commission and this commission should be following the way Congress set up, we're just faithfully taking the factors where they bring us, and coming to a point of where if we have periods where the commission has done proper work and the stakeholders have advocated as such, we shouldn't be afraid of then making those amendments retroactive, because that's the way the system was set up.
Thank you so much for being here. I'm curious, as we assess the burdens on the courts that a retroactivity vote would entail, to what extent you two think it would be relevant or not relevant, the commission's decision on retroactivity last year. Because as you noted, the commission estimated in its retroactivity impact analysis that up to about 19,000 defendants would be eligible for reductions. And of course, the number that have moved thus far have not yet reached that outer limit. And courts there was a delay in the execution date, implementation date, and a lot of those processes are still in process. And I wonder, as we evaluate burdens on the courts, whether that is a relevant factor at all, or whether you believe assessing the burden here really needs to be in a vacuum based on just each particular amendment.
Well, Commissioner Wong, I would say that in my district, which is the Eastern District of Kentucky, we don't have a defender. We have been very efficient working through the 821 retroactive motions. And so I don't know that, at least in my district, there would be any sort of cumulative burden if these were retroactive on the backs of the 821 amendments. We've worked through those. We've done it efficiently. It has turned out that most of the work, or a good lion's share of the work, falls on the defense bar. We're the ones that sort of have the burden of framing the issue and bringing the issue forward to the courts for consideration, and we're the ones that reach out typically to the U.S. Attorney's Office and try to form consensus on those, and so really to streamline and make that process efficient. Of course, with this amendment, there's far fewer potential defendants who can benefit or can have the opportunity to benefit. So it is our position, and sort of the PAG collectively, we discussed this issue, and it was sort of our group conclusion that this would not substantially increase workloads to the effect, to the point of shutting down the system or causing delays in the system. We think it's a very manageable number, especially given our collective experiences with the 821 amendments.
VC Murray?
I had another kind of workload question. So when we were doing our hearings on Amendment 821, we had an excellent witness from the District of Maryland on behalf of the defenders who talked about the Maryland process and said, look, when this comes to my district, we have a process for triaging them. We're going to triage them to the point where basically only the meritorious ones get to the court. And I don't know if you've seen the data that came out on 821, but she was exactly right. Maryland triaged, I think for at least one of the two 821 amendments, I think there was like 100% grant rate in Maryland. But Maryland's the only district like that, it turns out. Like the average for the other districts is like 50%. And so I'm wondering, and the kind of backdrop to my question is that every judge and every probation officer we heard from said, we're swamped with 821, like please don't do this to us again. And we don't have to take those at face value, but we have to think it through. Like what's happening in Maryland that's not happening anywhere else? And is there reason to think that this set of amendments will be more Maryland-like than the last set?
Well, one, I would agree. She is an excellent witness and a great colleague that we've worked with a lot of defenders' offices across the country to implement those exact processes. So I'd start by saying that the process is really an important part of this in order to triage. I often like to describe retroactivity as the same way astronaut Mark Kelly describes going to Mars. It's not rocket science, it's political science. You want to work with your stakeholders, you want to figure out cases or otherwise. As far as what is different in other districts, one of the bigger differences with 821 and the grant rates, looking and talking to colleagues and kind of digging into this because I myself was curious, is you have a lot more denials that were based on discretionary relief because you had different, especially with the 0-point offenders and some of the eligibility criteria. So that was a difference from some of the more rote applications otherwise. In some other instances, there were some of the eligibility criteria that needed to be litigated, and most of that has been done now over the last 6 months, but that also accounts for some of the denial rates that differ across the country, so you have larger numbers. So I wouldn't take that to be really an indication that there's efficiency some places and inefficiency others. It really is just a matter of being able to screen and understand of which cases are being put forward in the triage system versus some other places because of the higher numbers. For instance, in the Middle District of Florida, we're one of the larger districts in the country, we tend to have just more individuals that are arguably eligible as the law is developing otherwise. But I do, if I could just briefly point to the fact of being swamped and really Commissioner Wong's question too of like, should we be looking at this in a vacuum or otherwise? I think I would take a little exception to being swamped because I think what my colleague was saying is really my experience as well. In my current role, when the commission issues impact studies, I meet with defenders across the country as part of my job to understand what types of cases are still out there, where we can help, how we can move these cases forward. I can tell you, it may be anecdotal, that by and large, most of the heavy lifting cases have been completed. The conversation has very much shifted to the potential retroactivity for next year. When we talk about cases that are still out there, there's some other logistical concerns, perhaps with BOP or otherwise, but it's really not on the matter of the courts or defenders or practitioners' abilities to process cases. So I think efficiency is only going to increase as we're going forward, and the commission should be confident because we're dealing with a smaller universe, and we want to get this work done early in the triage, that you're really not going to see these inefficient rates, and the statistics should indicate that otherwise.
Thank you. I have one final question, I believe. With respect to, I think Commissioner Boone talked about the CLC, and there were some other comments that focus in on the finality, and I think you've address that in the context of maybe there's a distinction between the habeas type cases and what we're dealing here. But there are many who submitted comments that talked about the impact on the deterrent effect of applying guidelines retroactively, how it might affect deterrence. If you've seen that argument by those, how do you address, what is your response to that, the impact on deterrence that retroactivity may or may not have?
Well, I'm very glad you asked that, Chair Reeves, because that is it's an argument, and I'm sure when the defenders submit their reply comments, we'll have more to say about this as well. But the very first thing is the statement that without finality there is no deterrence. Not only is a line taken from Teague, but it's a line that has no basis in empirical support. There are no studies that we have looked at that we're aware of that support the idea that finality is correlated in any way with deterrence. In fact, the contrary would be true. There's recidivism studies, including those done by this commission, and several in terms of retroactivity, where retroactivity has no negative impact on recidivism. So when we're looking at the studies and the empirical support, the correlation between finality and deterrence is not there, whereas we have positive empirical support for retroactivity not impacting public safety.
Okay. Thank you, gentlemen, and you've set the standard here for comments, maybe for everything else, maybe not for time, but I appreciate you so very much for making yourselves available. Thank you. We appreciate you. Our second panel provides us with a perspective of our advisory groups on this issue. And ladies and gentlemen, our advisory groups are very important to the commission. And again, we appreciate the sacrifices and time that all the members who participate on our advisory groups give to us. We appreciate you deeply. First, we have Manny Atwal, who serves on the United States Sentencing Commission's Tribal Issues Advisory Group. Ms. Atwal is a first assistant defender in the Office of the Federal Defender for the District of Minnesota. Second, we have Jill Bushaw, who is the chair of the Commission's Probations Advisory Group and is the Deputy Chief U.S. Probation Officer from the Northern District of Iowa. Finally, we have Mary Graw Leary, who is the chair of the Commission's Victims Advisory Group. She is also a professor at the Catholic University of America in Washington, D.C., where she focuses on criminal law, human trafficking, Fourth Amendment, and victims' rights. Ms. Atwal, we're ready when you are.
Thank you, Chair. Can everybody hear me all right? Yes. Good morning, everybody. And thank you for including TIAG, Tribal Issues Advocacy Group, here today. Our committee, which I think is important for everybody to know who's on our committee, includes Judge Ralph Erickson from the 8th Circuit, a current and former U.S. attorney, a tribal judge, a law school dean, a practicing tribal attorney, and 2 attorneys from the Federal Defender's Office, including me. I have been an attorney, as Chair Reeves just noted, with the District of Minnesota since 2001. During that time, I have represented hundreds of clients from Indian country, including going to trial with those individuals. I have been a part of our office's what I call retro relief team for many years, including the crack retro, the drugs -2 amendments, and now the 821 amendments. It is based on my personal experiences and comments from my committee that I make my comments here today. Judge Erickson had the opportunity to speak to each of you on March 6, 2004, in regards to why these amendments, particularly acquitted conduct, was so important. In a letter we wrote to you on June 21st, 2024, where you supported retroactivity of all the amendments. Today, on behalf of TIAG, I want to encourage the Commission to make the amendments, acquitted conduct, retroactive for a number of reasons. We took direction from each of you when we were deciding whether or not we would recommend retroactivity. We discussed the magnitude of the amendments, the purpose of the amendments, and the manageability of the amendments. And some of these were the concerns you just talked to the previous panel about. Based on that, based on those concerns that this commission has, we again encourage the commission to make retroactivity for acquitted conduct. Fairness and trust requires you to do so. Let me first begin with manageability. TIAG's concern is with clients who are sitting in prison for crimes committed in Indian country. The acquitted conduct amendment, if applied retroactive, will be a low number. We know this because of the amount of trials that have happened in from Indian country. It will not be overburdened. We understand that it may be a more factual intensive type of amendment, but it's doable. We have handled retroactivity very smoothly in my district. We team up with probation, the district court, the U.S. Attorney's Office, and the Federal Defender's Office. We send letters to clients to say, hey, you might be eligible for retroactivity. This is what our concerns are. Please let us know if you want us to represent you. We then have bi-weekly meetings where we discuss with the U.S. attorneys, can we do a joint recommendation? We did the same thing in 2007. We did the same thing for drugs -2 for compassionate release cases and now 821 cases. It will be easy to review the docket in these cases where there has been acquitted conduct, where there's been split verdicts. We can review the docket, we can review the PSI and determine eligibility quickly and efficiently, and then file those motions quickly and efficiently. It is manageable, and this amendment is so important to people in Indian country that it be made retroactive. Why is it so important? It is important to create, as I stated earlier, fairness and trust in the system. Already individuals in Indian country have a distrust of our system, and rightfully so. So many times judges are faced with questions, hey, I don't understand, why am I being treated differently than if I committed the same crime across the street? So already judges, defense attorneys, and prosecutors alike have to deal with that question many times when we see individuals from Indian country. So let's make it a little bit fair. How so? At a minimum, we should say acquitted conduct is one way that we can make it more fair, and it shouldn't just be for folks that have committed crimes before October 30th. It should be for everybody. It should be for people that were sentenced a week ago, a month ago, 2 years ago, 10 years ago. It should include them too. There's a fair amount of trials in Minnesota and other districts that are from Indian country. And most of the times it comes down to split verdicts, and here's why. It may not necessarily be a question of was an assault committed, but it may be was an assault committed with a dangerous weapon? Was the assault resulting in serious bodily injury? So many times it comes out as a split verdict. Just this past June, my office tried a case where the allegation was an assault with a dangerous weapon. Each with different guidelines. The assault with a dangerous weapon, much, much higher. What happened? Split verdict. Jury came back and said, guilty on the assault, not guilty on the dangerous weapon. Now, I don't know what our sitting judge is going to do come time of sentencing. We'll have to wait and see. But let me tell you about a case where I had a similar situation. In the case, the client was charged with sexual abuse of a minor and aggravated sexual abuse. He was acquitted of the aggravated sexual abuse, which had higher guidelines than the sexual abuse of a minor. My client, Mr. Morris, was sentenced as if he had been convicted of the aggravated sexual abuse. To then turn around to a client and try and explain that, where they already feel from Indian country that they are treated unfairly by us, that is really hard to explain. And then to say, it's okay, have trust in the system, and say it with a straight face. We have an opportunity now, each of you have an opportunity now to right a wrong and make acquitted conduct retroactive. Thank you, Your Honor. Thank you.
But you're able to wrap that up in your comments and response to our questions.
Thank you.
I'm sorry, Ms. Bouchard.
Good morning, and thank you again to Chair Reeves and the Commission for the opportunity to provide the Probation Officers Advisory Group position on acquitted conduct. As the Commission is aware, POAG submitted prior comment outlining our workability concerns with the acquitted conduct amendment. While the final amendment did resolve some of the issues we had identified, the concern with applying these new provisions on previously sentenced cases is the primary basis for POAG's recommendation that this amendment not be made retroactive. A sincere concern at this point is the fact that how many cases will be impacted is difficult to determine, which prevents courts from properly preparing for implementation. The indication that there are close to 2,000 potentially impacted cases does not represent the number of motions that will be filed or the actual cases impacted. It is simply an estimate based upon a sampling of cases. Unlike prior amendments, determining how the case was impacted is far from a simple process. The acquitted conduct amendment doesn't just pertain to a base offense level or a criminal history point. It doesn't just impact one type of case, and it doesn't just impact one scoring issue. An officer cannot simply refer to one paragraph in the pre-sentence report to determine if the case was impacted by the amendment. Further, the relevant details needed would not necessarily be available within routine court records. In fact, proper due diligence would likely require a review of the sentencing transcript to sort out issues such as findings related to prior objections and the extent that the court included acquitted conduct in determining the guideline range. This is assuming the initial record was sufficiently detailed, as the record the court made at sentencing was informed by the process in effect at the time of the hearing. The commentary submitted in response to this amendment acknowledges that additional fact-finding will be required. The degree to which this is true, we believe, is probably understated. And this speaks to our concern that we believe this is a uniquely complicated amendment to apply retroactively. As we noted in our written testimony, acquitted conduct may have been given varying levels of consideration at the original sentencing hearing. Therefore, the extent of the impact of this amendment, if any at all, cannot be determined until there is a full analysis of the case. Some of the commentary submitted takes the position that the amendment will result in a substantial change to the sentence. Substantial impacts don't automatically involve a large-scale analysis, but in this circumstance, we believe a substantial change to the sentence will first require a substantial change to the offense level computations. Such an amendment to the information that can be included as relevant conduct is significant. Summarizing relevant conduct in the offense conduct section is step one of every pre-sentence report. Relevant conduct serves as the baseline for the scoring of every single guideline calculation, from the offense levels under chapters 2 and 3 to the criminal history computation under chapter 4. Because relevant conduct is all-encompassing, an amendment to what can be considered relevant conduct has such a broad impact that we believe it would effectively resemble a full resentencing. Further complicating the process is the fact that the sentencing hearings for trial cases are understandably contested as a matter of practice and therefore more complex. The court already heard the evidence and made findings based upon a preponderance and imposed a sentence after considering the 3553A factors. Making this amendment retroactive would require courts to start over at step one, apply new criteria that amends relevant conduct, amend all impacted computations, and address first impression issues without the benefit of the case law that will develop on this issue. Some of the commentary submitted also advocates for it being made retroactive because the judicial system succeeded in processing prior retroactive amendments. That would be true for any retroactive amendment ever imposed. The public servants who make up the federal judiciary wouldn't let justice fail because of workload implications. Each potential retroactive amendment consideration should include a full individualized assessment, and the magnitude of the impact and the difficulty in application are factors in whether to make an amendment retroactive. In this case, they are interrelated. The difficulty of the application impedes the ability to assess the magnitude of the change. While not impossible, the workability challenges for this amendment would tap judicial resources at an extremely high level to accomplish an uncertain outcome. For these primary reasons, POAG respectfully recommends that this amendment not be made retroactive. Thank you.
Thank you. The VAG has two core observations that preclude the retroactive application of this amendment. First, that Rule 4.1a must mean something, and without the information necessary to overcome the preference for proactive application of an amendment to the guidelines, the Commission simply cannot proceed with integrity to do so. Secondly, even if you could rely on the data from the impact analysis, there's no basis given the factors to consider. First, with regard to the lack of information from which you must base your analysis of the required factors. And this concept, which is in our written commentary, really takes new light in light of the Criminal Law Committee's comments that have been referenced already, that this trend to make retroactive all amendments is undermining the Commission, the guidelines, and the criminal justice system. Rule of Procedure 4.1a is clear. Quote, generally, promulgated amendments will be given prospective application only. The word only is in that rule for a reason. Retroactivity is different than amending. Yes, the guidelines has an amendment process and it's meant to be breathing, but not retroactivity. That is different. And one example of what Congress intended is under 3661, judges can still include this information anyways. So there is an exception to this preference for proactive application, but the only gateway to that is if the Commission can overcome this preference, and it must overcome it based on data. The data is simply not available to you, and the data is not available to you because it's impossible to assess. So as Chair Murray mentioned, the delta, the kind of information this Commission usually has, is absent. It has extracted data from the 13,000 offenders who went to trial. That's it, not even went to trial with an acquitted charge. So to unleash this exceptional remedy of retroactivity without knowing the effect in light of what every single judge and the Criminal Law Committee and the POAG and the Department of Justice have pointed out will be, in one reference, a debilitating amount of work is unconscionable. To decide otherwise would mean that Rule 4A means nothing, and surely it means something, and it would also mean that with the language in this Commission's introduction to the guidelines, where it says Congress first sought honesty in sentencing, that sentence means nothing. Because finality and honesty in sentencing are used interchangeably. The concept of finality is not only a habeas concept, it is a concept that is the bedrock of the Sentencing Reform Act. But beyond that, even if you could rely on this data, the factors do not support it. The VAG wants to focus on the difficulty of amending on 2 points of specific interest to the Victim Advisory Group, because POAG has made a very critical observation in their written observations. It's not only the complexity of having a hearing where we're going to speculate what facts a judge would have found if he had different rules at the time. It will have implications for other enhancements to the sentence, raising questions about who is a victim, whether there should still be restitution, whether there should still be a stay-away order. And given that in the end, the sentence may be the same under 3661, it may be similar, the end result is what? Victims will pay, because victims will be stripped of their status as a victim potentially, they might be stripped of their restitution, etc., and the sentence might be somewhat the same. Secondly, and I really have to clear up this point, we've heard so far today that the aim will be to resolve without protracted hearings, and that this is usually a joint recommendation. Make no mistake about it, 3771 requires that there be a hearing and all the victim rights be triggered. This isn't just a resentencing. 3771 says any public proceeding involving the crime. There has to be factual findings to determine what should be done in these cases. That is a hearing involving the crime. All the victims' rights are triggered as a result of that. With regard to purpose of the amendment, I don't know if people are only reading part of what the commission said, but the commission said a purpose of the amendment is to clarify what these terms mean. This commission clarifies things all of the time, and to clarify things all of the time, and to say that every time it clarifies things that it's going to involve retroactivity flies in the face of the Sentencing Reform Act as well as the rules. There's been a lot of discussion about fairness and trust in the system, and gosh, the Victim Advisory Group agrees entirely with that. One sure way to undermine fairness and trust in the system, one sure way to undermine promotion of the rule of law is after a sentencing in which everyone has been told the sentence, the rules, and it will be final, to 2 weeks, 2 years, 10 years later, come back and then say, forget that sentence. We're applying new rules, okay? And we don't have the data to support applying these new rules. The commission wasn't really sure the effect that this would have, and the consequence that will certainly result is that victims will be re-traumatized and be told, in some instances, they're no longer considered victims. That will undermine the system. Thank you.
Turn to my colleagues for any questions of this panel.
Again.
Yes, all right.
This is for the TIAG, and just a kind of a numbers question. I think on page 2 of your letter, you point to some statistics about federal indictments where they're concentrated in districts with Indian country jurisdiction, and then say that this accords with your general intuition that cases involving Native Americans proceed to trial with greater frequency. Do you have any more concrete numbers than that you've been able to run down, or is it just kind of a sense that these cases go to trial more in Indian country, and therefore that this amendment, if made retroactive, would have a corresponding proportionate effect in those districts?
Beyond the stats that we listed in our letter on page 2, we were just talking in general experience, because again, we have people on our group that are from Oklahoma, from Montana, Arizona, Minnesota, South and North Dakota, each that has Indian country. So we're basing it on our personal experience and then on the statistics that we know in our letter.
Thank you.
Thanks. Thanks to all of you. I have a POAG question. This is on page 8 of your letter. You mentioned that several of the members from POAG said that Amendment 821 retroactivity which would have small impacts in some cases on, not all, obviously, but in some cases on imposed sentences, could, quote, have unintended consequences for inmates in the Bureau of Prisons, such as making them ineligible for programming and changing their good time credits, sometimes resulting in a computation that results in a longer rather than a shorter sentence. Could you, that was something I had not heard before. Could you just hum a few more bars?
Absolutely. So POAG has met several times over the year, and during those meetings, we would just have conversations about how retroactive is going and what issues we were running into. And so that paragraph was a summary of those discussions. And there was a circumstance with the First Step Act credits and whatnot, after somebody received the Amendment 821 reduction, they actually increased their sentence by 4 days. But I'm assuming the Bureau of Prisons, just with the new changes to how the First Step Act was adjusting their credit combined with how it was, but it did definitely, at the end of the day, lengthen their sentence. I don't know that the BOP proceeded with making them stay that extra 4 days, but it just was an observation that we had made. But that's part of that paragraph. We wanted to just point out, too, just other implications when these reductions result in a sentence that ends abruptly, just kind of the impact on defendants. And then this could come into play as well with the acquitted conduct amendment, as we indicated in our writing that, this extends quite a ways because you're impacting relevant conduct. And some of our discussions on that, it wasn't mentioned in our paper, were like if there was a related state charge and that was dismissed, and then that was the underlying acquittal in the federal case, then ordinarily that would be credit off their federal sentence. But if it's no longer relevant conduct, then the credit would need to be readjusted. So some of those things could come into play with this type of a retroactive amendment.
these made.
Thank you. Thank you all for being here today. We really appreciate it. Ms. Atwell, I have a question for you, kind of based on something that's in the TIAG testimony, but also based on your experience working on the past retroactivity. But in connection with TIAG's perspective that this would be manageable if implemented retroactively, can you speak a little bit about your experience with the screening process on those committees and how many cases, how that would work in this situation, addressing this issue, and whether you think that that process has that sort of filtering, whether that's possible with this topic or whether it's unique to things that have come in the past?
I do think, as I noted, that it would be doable. And as a committee, we discussed what we've done in Minnesota, where we team up with district courts. So I would anticipate in a case, if this was made retroactive, we'd ask district court for Indian country trials. And then we can look at those dockets to see, was there actually acquittals, whether it was acquittal and a guilty verdict, and be able to look, first of all, right at the docket, and then be able to team up with probation, and then look at the PSR, and to determine it that way. So in the past, that's what we've always done. We've teamed up, we sit together, we meet every 2 weeks on a Tuesday morning and discuss, here's our list, how far have we gone? Have we sent out notices to clients saying, hey, we don't think you're eligible, and here's why? We think you're eligible, and here's what we're willing to file on your behalf, and then take the next step and filing those motions. In those meetings we have, it's always with district court, with probation, and a representative from the U.S. Attorney's Office, and a representative from the Federal Defender's Office. I anticipate we would do the same thing for the Indian country cases and any other cases where there is acquitted behavior. We would have the same system set up. It has worked smoothly since 2007. I have no doubt we would be able to do it just as smoothly if these amendments were made retroactive.
All right. Again, thank you all for your submissions. This is a question as well for Ms. Atwell. So one of the arguments for the acquitted conduct amendment is that it impacts a fundamental issue of fairness, undermining the jury process, and certainly that resonates. But one of the arguments as far as, so that's one issue, and today we're talking about the issue of retroactivity, and our guidelines for determining what should be made retroactive. And one of the arguments that was made by POAG, which I thought was interesting and I'd like for you to respond to, is the argument that, regardless of the guidelines manual that was in effect at the time that the defendant was sentenced, and regardless of whether the amendment is made retroactive, acquitted conduct remains relevant conduct and something that the sentencing judge may consider under 3661 when evaluating the 3553A factors. So for purposes of retroactivity, is this a fundamental issue when the court may consider it, and probably should, if they believe that there is, sufficient indicia of reliability related to this evidence, when the court can consider it anyway under the 3661, under the statute and the statutory factors?
It does make a difference because it's the starting point, right? So if the starting point with the guidelines is we're not going to consider acquitted behavior, so the guidelines starting point is going to be different. And then, as you just noted, the sentencing judge can take into consideration under 3661 whether or not to consider that conduct. But that starting point should have a different anchor than instead of starting up here, start up here and respect the jury's verdict and have that fundamental fairness saying, okay, we're going to start off here, and then I can take into consideration these things if I want to, and if so, by how much. So I think the difference is where the starting point would be.
Yeah, and I understand the difference is the starting point, but again, I do think, just like I believe that the fundamental fairness issue as far as making the amendment, undermining the jury verdict resonates as an issue of fairness. But again, when you're talking about actual sentencing then with the sentencing judge, when this is information that we can and probably should consider regardless as relevant conduct, I think that's a slightly different issue.
Respectfully, I disagree. And the reason being, again, is if you just start off with that point, let's just talk about fairness, right? Let's just talk about fairness. That's one of the reasons this amendment has been made, right? To not consider that acquitted conduct. And so anybody that's sentenced after November 1st or commits crime after November 1st, that judge can then start off at a lower anchor, right? Saying the anchor's right here, and then decide whether to go up. It should be made the same for anybody else before that. If it is all about fairness, then you should make it retroactive because it's going to be a different starting point. I think that does make a difference.
Yeah. But it's not all about fairness, we know that. There are other
True.
factors to consider, but yes, but certainly I understand your point, and thank you. Yeah.
I guess this is a question for all three of you that I've been thinking through how and whether this amendment is different than other amendments. I mean, it seems like several of our other amendments, including the ones we made retroactive last time, the kind of premise of the retroactivity is that we had something to add to the analysis, right? So if people had been sentenced based on a starting point that included status points, then maybe that didn't incorporate the fact that the knowledge that wasn't available at the time that they were sentenced, that status points didn't have as much impact on recidivism as we thought. Or when people were 0-point offenders and they were sentenced before our amendment, the sort of new data that we had available when we made the amendment that said, gosh, 0-pointers recidivated at a much lower rate than most people wasn't available. Here it seems like it's a little bit different. Like, what is the new information that the judge will have, right? So the first time around, the judge calculated the guidelines based on all available information, and then applied 3553 based on all available information. If we were to make this retroactive, we would be saying, okay, go back, calculate the guidelines based on partial information, right? Blind yourself to some of the information. And then when you're applying 3553, when you're like looking at the person as they truly are, look at all the information. It seems like there's something funny and different about this amendment than other amendments, partly because it goes to relevant conduct. That's more of a statement than a question, but I'm very interested in your thoughts about this amendment versus other amendments. Thanks.
We can also flip it the other way, right? So in one of the cases I was talking about with the aggravated sexual abuse and the sexual abuse of a minor, the judge in that case, it was back in 2007, 2008, said, I don't have any choice, Ms. Atwell. I have to apply these guidelines because that's what I'm told to do. I have to apply these higher guidelines. So it could very well be that a sentencing judge may say, hey, now I don't have to start off high with these guidelines. I don't have to do that. So it could be that a judge could see it in a completely different lens. And I think they should have the opportunity to think about it in a different lens.
The guidelines would change for sure. I mean, I agree with that, yeah.
So this is, I agree, a circumstance where there isn't necessarily new data. It's an evolving position to address public debate on an issue that's been a debate for a long time. But a lot of what we've tried to focus on in our writings and in our testimony is just really distinguishing this amendment from prior retroactive amendments. They aren't even really comparable. Prior amendments were very simple and addressed a narrow issue. This is such a broad impact that it's difficult to articulate, like how complicated we think this would be if the court were to resentence it. But at the end of the day, say this is made retroactive, the computations will be different, but everything the court sees and receives and hears would technically be the same. It would just come in at a different point in the hearing after the computations are made. So that's the big way we want to really distinguish this one from prior retroactive amendments.
I would say it's different in a few ways. One is it's requiring the judge, and again, as every single judge, unless I misread it, my memory is every single judge opposes this and talks about the challenges here, as does the Criminal Law Committee. And they talk about it's not often the same judge, or it's so long ago, et cetera. So what it is speculating from an inadequate record, because different findings would be made, different statements would be made, et cetera, about why a judge is doing something or whatever, from an inadequate record, about what that record would look like if the court were going to apply a different set of rules. So in our mind, that's fundamentally different, and that's why we agree with all of those groups, the POAG, the Department of Justice. This isn't an easy hearing. This is going to require some real findings, et cetera. It's also different, though, I would say, fundamentally, in who it's going to affect. And I think it's worth pointing out, who will it affect? Murderers, drug traffickers, firearm traffickers, robbers, thieves, money launderers, child pornography offenders, abusers, and kidnappers. Now, I don't say that for the sensationality point. I see it because that's just the top 10 of offenders who will be affected by this, just the top 10. And of those, according to your commission's report, they have the highest recidivism rate. So the fact that retroactivity may not change recidivism rates, those are rates that are already really bad. And how it will change it is there will be victims, in the case of firearms offenders, 70% of them are expected to reoffend. That will happen a lot sooner. That's another way that it's different. The public impact is tremendous.
Thank you all so much for this lively discussion. Your testimony and statements are received. Thank you so much. Panelists will provide us with criminal law practitioners' perspective on retroactivity for Part A of our circuit conflict amendment. First, we will hear from Paige Messick, who is the appellate chief for the United States Attorney for the District of New Mexico. She joined the U.S. Attorney's Office as a trial attorney in 2007 after clerking on the 10th Circuit Court of Appeals. Second, we'll hear from Adil Bashir, presenting a public defender's perspective. Ms. Messick, we're ready when you are.
Good morning, and thank you, Chair Reeves and Commissioners, for having me here today. The Department appreciates the desire for uniform treatment that motivated the amendment to the enhancement for altered or obliterated serial numbers. But as a number of the written comments observed, this isn't an amendment that rectifies a fundamental injustice. And so it's especially important to consider the costs of retroactive amendment. In our written comments, the Department has explained why the finality of criminal judgments, public safety, and burden on the courts and litigants all counsel against retroactivity here. I'll focus today on this last concern because the practical challenge of assessing eligibility for a reduction under this amendment will place a significant burden upon our busy courts. The Commission has received comments from other stakeholders suggesting that determining eligibility under this amendment would be straightforward because the new test is an easy right-line rule. But the practical challenge we're referring to isn't in applying this bright-line test in new cases. It's in applying it to sentencing records that weren't developed with that test in mind. In many cases, the PSRs won't contain enough information to determine whether a serial number has been rendered ineligible, as the amended provision requires. In that situation, a number of things could happen. In some jurisdictions, district courts will be restricted to the original record, because many circuits lack controlling authority on allocating the burden in this context. Some judges will find that a silent record means that a defendant hasn't established eligibility. Others may decide that a silent record means that the government can't meet its burden to establish that the enhancement applies. In other jurisdictions, district courts may have the discretion to take new evidence, often leading to the need for an evidentiary hearing. In these cases, prosecutors and investigators will be tasked with digging out evidence in closed cases, and sometimes this evidence simply won't exist anymore. And of course, the availability of the evidence at this late date has nothing to do with the actual offense conduct. All of these cases will require litigation, And the results of this litigation will frequently depend on factors other than the state or the true state of the serial numbers at issue. In the end, we may well find that an amendment that was designed to remedy disparities has in reality generated new ones. To get a sense of the challenges ahead, if this amendment is made retroactive, we identified all cases with this enhancement sentenced in my district from fiscal years 2019 through 2023, so a 5-year period. We found 47 of them. We then examined all the PSRs for information about the state of the serial numbers at issue. Only 8 PSRs had the sort of detail that would put the question of readability beyond dispute. These PSRs either used the term illegible, or more commonly, they explicitly noted that the serial number couldn't be traced because of the alteration. In every other case, that is, in more than 80% of these cases, the issue would likely be open to dispute. I would note in that only 4 of these 47 cases do there appear to be any photographs of the guns or serial numbers at issue in the sentencing records. None of the other cases appear to have that sort of evidence. But even in those 4 cases, which have the best evidence of the group, those photographs won't always resolve the question of whether the number is legible to the naked eye. There's good reason to think that in many cases where the records are silent, it's because more detail would not have benefited the defendant. In all but 3 circuits, defendants had an incentive to challenge the enhancement if their weapon's serial number was still legible. 2 circuits required illegibility. In the other 7, it was an open question. So there was an opportunity in these 9 circuits to avoid that enhancement through an objection. And beyond that, if the alteration was minimal, that might have been a good 3553A argument in any circuit. The government, on the other hand, wouldn't have had any incentive to put additional evidence into the record in the absence of any objection to the PSR. In sum, making this amendment retroactive would mire the courts in hard questions and in potentially unresolvable factual disputes. As Judge Williams of the Northern District of Iowa said in his written comment, the difficulty of this task cannot be overstated. In our view, this rule would shift resources away from combating the epidemic of gun violence and other violent crime to relitigating old cases that raise serious public safety concerns. The department therefore asks that the Commission not make this amendment retroactive. Thank you.
Good morning again, Commissioners, and thank you for the opportunity to speak on behalf of the altered serial number amendment on behalf of the defenders. Now, geography should not dictate sentencing outcomes any more than the date of sentencing. And before this amendment, there was a significant disparity in how different circuits applied the 4-level enhancement for altered serial numbers, even when the serial number was still eligible. This resulted in racially disparate application of the enhancement. And the Commission has aimed to rectify these disparities with the unaided eye test. Now, applying this amendment retroactively is crucial for ensuring fairness across all jurisdictions for 2 primary reasons. First, this amendment carries a significant impact, potentially larger than most previous retroactive amendments, due to the 4-level enhancement involved. This factor alone supports retroactive application. At the same time, the number of cases affected is relatively low. As we just heard, there are a few handful or maybe even less of cases eligible per district. And when we start looking at the records, we're going to have even fewer numbers there. That indicates that there'll be a minimal burden on individual district courts. Second, retroactivity would help address unwarranted geographic and racial disparities, as the enhancements have disproportionately impacted Black and Hispanic individuals. And ensuring that sentencing practices are fair across all demographics is essential for upholding the integrity of our justice system. Now, to address the feasibility of applying this amendment, I think we agree on a lot of the fundamentals, but maybe disagree on how this would play out on the ground. So I draw on from my experience of practicing in one of those circuits where the 4-level enhancement applied even where the serial number was legible to the naked eye. Now, our best practices did include objecting to the application due to the existing circuit conflict and establishing a record. So when the firearms serial number was legible, we'd usually argue that in mitigation and preserve the record. So yes, there will be information and there was an incentive. Conversely, when the serial number was ineligible, the PSR typically indicated as such because it's an aggravating factor, because as this Commission indicated when it adopted the unaided eye test, the whole purpose of this amendment is to punish those with the greater culpability of being unable to trace a firearm. So this is all to say the feasibility of applying the amendment, our experience and my own individual experience is that we will in fact have records to work with for eligible individuals. Now, fair enough, there's going to be some circumstances where we need to dig deeper than the PSR. But even then, the fact finding is really quite straightforward and really just determines involving whether the serial number was eligible to the unaided eye based on existing records. And this is very important because unlike a different proceeding where we're taking in new evidence, we're based on fixed records. So while we may have some instances where the PSR is not directly addressing the serial number's legibility, we'll have other records to rely on. And the lion's share of that work and the responsibility, both typically and historically, lies with defenders, who take on the lion's share and the bulk of triaging, identifying, and determining eligibility, and figuring out which cases are the best cases to put forward in terms of not only eligibility, but also establishing discretionary relief. As a practical matter, it's those cases that where we have records to work with and where we have clear indications of legibility and good 3553A factors. Those are the cases that courts will have before them, and those are easy cases to deal with. On the flip side, where we have silent records or other factors, those are easy cases for courts to also dispose of because not only do we have to establish eligibility, you have to establish discretionary relief. But in all events, it bears emphasizing, we're really talking about a small universe of cases again, and it's a consistent theme throughout today's proceedings. We're not talking about a huge number, but a relatively small number with a large impact. So in conclusion, this commission has an opportunity to ensure fairness and uniformity in sentencing by making this altered serial number amendment retroactive. And evidence and past experience shows it can be done effectively and without compromising either public safety or overburdening the courts. I mean, thank you and welcome your questions.
Thank you. I turn to my fellow commissioners. Say hey.
I'm happy to start.
You're the man.
Making it a habit right now. Mr. Bashir, can I ask you about the last category of cases I think that you're mentioning? What I think you called, you said that cases involving a silent record would be easy cases. And I'm trying to figure out, is that because you think that a defendant, in one of the cases that Ms. Messick described, for example, where there's perhaps inadequate information to determine legibility in the existing PSR, do you think because of the burden allocation, the defendant just cannot establish eligibility? Is that why it's an easy case?
Yeah, so let me answer that in two parts, and I think it kind of goes to a global point when we're dealing with retroactivity that, and I think this is just very important when, for setting the stage. This isn't a circumstance of where we just put a motion forward and we're waiting for a response or otherwise. The process really begins behind the scenes. It begins at that triage stage, it begins on the evaluation stage. So, and this would just be my experience if I was doing this now back in my old district or even with colleagues in the Southern District of Florida. The reason I say it's an easy case is because when you triage these, the first category you're always going to look for are those consensus, joint stipulation, clearly legible cases. That's the first tranche that you put forward. Then when you go to this next phase of where the record is quote unquote silent or where there's less information, now as a defender and you're speaking to your client, you're going to be having these tough conversations of saying, hey, not only do we have to establish eligibility, I have to convince this district court judge that this is a case in which the 3553A factors warrant relief. In making that type of decision, as an ethical matter and as a good faith matter and a credibility matter, I need to convince my colleagues, probation office, and a court that this is a case that's worthy of relief. It's not an automatic right. So when I say it's easy because it's really a case where we have something to point to, where I can go to my colleagues and I can say, hey, there's something in the record here. And this is before we even do the filing. Really, if you talk to a lot of districts across the country, the practice involves showing, meeting with, I think earlier panels were speaking about this, we'll meet in working groups or we'll meet before the cases occur. So that's really kind of the macro point, but to directly answer your question, the other point is really this burden allocation, that while I agree the circuits are a little bit different in terms of who bears the burden, as a practical matter, we do know that because we're dealing with discretionary relief, it's on the movement and it's on defenders to really show our work. Because we want to do the best that we can in a good faith manner to not only get those individuals who are eligible for relief, but also, help those who are otherwise deserving of relief as well. And you don't do that by just blanketly throwing cases out there or doing so in a manner that will reduce credibility or it's easy to be dismissed.
That's just one quick follow-up, I hope, but I'm just trying to understand what you mean by saying a fixed record in the same point, because, like, do you understand, for example, that if the record, if the PSR, for example, were bare bones in its description of what the number looked like, that the court could consider things like photographs that hadn't been introduced, that were maybe shared with the probation office, but never actually introduced in the earlier sentencing proceedings? That's what I'm trying to figure out, is what it means if the parties have a chance to shape the record with more information, or if you think it's truly whatever that was in the record before the judge at the time of the original sentencing, and that's it.
Yeah, so not sure I would limit it just to sentencing, but I think the best way to distinguish it, a fixed record is everything that was before, because you potentially had a trial, and you possibly had other hearings, you have other information. I think the record or transcripts available, et cetera, is what a court in a 3582C2 proceeding, or speaking to colleagues like I was saying, this is information that you can consider to make a finding. That's what I mean by fixed, as distinguished from a new hearing where you would take in additional evidence. So now, hey, now we have a picture of the firearm that was never taken before, and we want to, that, I think all the parties are in agreement. That is not what 3582C2, the Supreme Court has been clear about that. That's not what prior practice. So we're not here to suggest by any means that the record would be opened or expanded, or to use in habeas terms, a new evidentiary hearing in that capacity. So that's what the terminology fixed by that matter is really restricted to what was before the court.
Thank you.
I just have a follow-up on Commissioner Meisler's question. So I just want to make sure I understand. So in the case of a, quote, silent record, so where there's no picture of the gun and the PSR, PSI doesn't say anything about, that lets you know which way, whether the serial number was legible, you think that the defendant is or is not eligible? Like, who bears the burden there?
So,
Leaving aside 3553.
Yeah. I think it is fair to say that some of the circuits are split or do not have settled case law exactly who has the burden. In the 11th Circuit and in our circuit, the defendant, the movement, would bear the burden in that circumstance. So going back to why I would categorize that as an easy case, without that information, we would not be able to establish eligibility typically in our district. And, yeah, in our
circuits, it would be a slam dunk for eligibility?
No, I don't think it would be a slam dunk for eligibility, and it would be depending on the way the courts would look at it. It would either be an open question, or a court could potentially go over the eligibility question and go straight to the 3553A if they didn't want to resolve the particular question. So I'm not sure it would be precise to say a direct answer in terms of a quote-unquote silent record. That eligibility is automatically established. What I'm saying is, as both a legal matter, but as a practical matter, it is really the movement's incumbency to show eligibility in most circumstances. So as a practical matter, those type of silent cases, I'm not going to sit here and say that individuals won't file motions, but I think by and large courts would find that there's not enough information here for me to establish eligibility is met here. So in terms of concerns that we're just going to have a floodgates of eligibility motions or otherwise, I think that that concern really is mitigated by the practical realities and how 3582 works.
Do you have anything to add, Ms. Mesnick? This seems like an appellate chief's wheelhouse on how the burdens play out across the circuits.
Yeah, just a few things. We don't have clear answers in most of the circuits. And so while the government can certainly hope that it turns out that the defendant will bear the burden of putting on additional evidence or pointing to evidence in the record, and we hope that it turns out that way across the country, we can't be confident of that. At a minimum, we're going to be litigating that question, litigating it in the trial courts, likely litigating it in the courts of appeals. And even if it turns out that the defenders don't end up filing a lot of these motions where the records are more or less silent on the state of the guns, that doesn't mean that defendants won't file them themselves. So just to give you an example, in the District of New Mexico, on the last round of amendments, the commission had 182 defendants on the list for both amendments together that it thought might be eligible. And some of those filed and some of them didn't. But 156 other defendants who were not on that list ended up filing their own motions in the District of New Mexico. And those are cases where, in all but I think 3, those were not counseled cases. And so that's 153 cases that the United States Attorney's Office is responding to in writing for the district court that the federal public defenders are not. And so when they say that they carry a lot of the greater share of the burden in these, that doesn't ring true to us because we have the burden of responding to all of these petitions that they aren't intimately involved with.
Any further? Commissioner Wong?
I just have a question. If the PSR is silent as to the legibility of the serial number and there aren't photographs, would available physical firearms be available for inspection? Do you think that's something that would be outside the evidentiary hearing or something potentially within the scope?
So I think that if it was part of the discovery, it's part of the record, that could be something to look at. As a practical matter, firearms aren't typically kept for as long as what we're talking about. It's something we have looked at our working group. We're talking about, I think, really on the margins cases, and it kind of goes back to, the earlier point too of like, what are we talking? How many of these silent records exist? I think what my colleague said is actually true, and we agree that for the most part you are going to have indications of eligibility that are pretty clear, and the fact finding is straightforward. And in other circumstances, you may not, but in those instances, there may have been a suppression hearing, there may have been a trial. That's when we're really going to have these pictures or evidence of photographs. So, the answer to your question is yes, you could when those firearms are there, but it's really, we're talking about the margins cases, and I don't think that's going to end up bogging down courts, by any means. And it really, even to add to, previous comments that were made, in our district and other districts practice as well as, we see pro se filings, we see these other types of cases. They're pretty easy to resolve. I think in talking to some working groups or probation officers across the country, 5 minutes, 10 minutes max, because you can just tell from a PSR or from a motion, sometimes people didn't even get the 4-level enhancement and they're filing motions. People are going to file motions regardless of anything this commission does. Answering the questions tend to be easy, and those tough questions, they're not nearly as tough when you get down to the nitty-gritty.
I just have one final question. Has it been your experience in the 10th Circuit that the judges are requiring the U.S. Attorney's Office to respond to every motion that is filed, regardless of whether, on its face, may tantamount to be, frivolous? I mean, we get motions now all the time where judges have disagreed with the policy statements with respect to meth, but the commission has not applied it retroactively and not done anything with it. Do the judges in your circuit require persons, the U.S. Attorney's Office, to respond to each motion, whether it's applicable or not?
Yes. Well, in the District of New Mexico, I can say that we have been required to respond to nearly all of the pro se motions. I can't speak for the rest of the 10th Circuit. I did not poll the other appellate chiefs. But in our district, we are being asked to respond to all of those motions.
Because whether we vote to make it retroactive or not, there will be incarcerated people who will file a motion saying that they're entitled to retroactive relief.
Oh, that's true. But if you don't make this retroactive, there may be defendants who still try to file because they would like it to be retroactive. I don't know if we would be required to respond to those. I'm thinking of the situation in which there is a retroactive amendment and defendants who are very likely not eligible file anyway.
All right. Mr.
Yeah,
Bashir.
can I add just one quick point
Yes, sir.
to your comment, not from the 10th Circuit, but just as a practice matter, because I think it kind of goes again to this practical burden point. Increasingly, districts across the country tend to use omnibus orders. I know our district does, others as well, that kind of regulate the how the trains operate, so to speak. So when you have situations of a lot of pro se motions or otherwise, it funnels that initial decision-making process to the defenders and otherwise. So that's something I would, encourage the commission, whether it's for this amendment or otherwise, to, ask district courts across the country to do, because I think that's a process that, reduces burdens on the U.S. Attorney's Office, but also increases efficiency on the other end of the spectrum.
Thank you. Thank you so much for your testimony. We're about to move into our final panel before we take a break. Thank you so much. Our fourth panel, which will present perspectives from our very important advisory groups on this issue. First, we have Manny Atwal speaking for our Tribal Issues Advisory Group, TIAG. Second, we have Joshua Luria, who is the Vice Chair of the Commission's Probation Advisory Group and is a supervisory U.S. probation officer from the Middle District of Florida. Third, we have Professor Leary speaking for our Victims Advisory Group. Ms. Atwal, we'll start with you again.
Thank you, Chair. I'm going to keep my comments brief. TIAG would like to rely on the letter that we submitted to this commission. We are encouraging this commission to make obliterated serial number amendments retroactive. We support it because, again, we don't feel like it's going to affect many people on Indian country, but it will affect some. So we do think it's going to be manageable and that we think the number will be small. And more so, it's an argument, again, I talk about the word fairness, but in this case, it really is about fairness. Defendants that are treated one way, that are similarly situated, treated the same, similar crimes, should be treated the same, no matter where you are. And as my prior colleague, Mr. Bashir, stated to this panel, it shouldn't matter about where you live geographically. You should be treated the same if you committed the same crime. So therefore, we're asking that the obliterated serial amendment be made retroactive. Thank you.
Thank you, Ms. Atwal. Mr. Luria.
Good morning.
Good morning.
Thank you for the opportunity to provide POAG's thoughts on the prospect of the retroactive application of the upcoming change to Section 2K2.1 B4B. POAG is not in favor of making this provision retroactively applicable. In our discussion of this proposal, we uniformly observe that there would be substantial evidentiary problems with a retroactive application. In previous testimony before the Commission, we articulate that offense conduct narratives rarely contain information that is outside of the information necessary to appropriately describe the conduct and to provide facts needed to analyze the guideline applications. Facts related to a new standard such as this will not have been assessed and included into the pre-sentence reports absent some notice that the naked eye standard now applies or may be used. The vast majority of cases for which retroactive assessments must be made will require an evaluation of the success of the obliterative efforts made on the defendant's firearm. The need for such an assessment opens up a myriad of difficulties. Is the weapon still in evidence, or has it been destroyed? If the weapon has been destroyed, does the government still possess an image or video of the weapon from which an assessment could be reasonably made? Can such an assessment be made from a digital image, as it seems that it could be better than the unaided eye? If the probation officer is able to assess the actual weapon and can read the serial number, but others involved in the case cannot, should that person receive retroactive relief? As the judge's naked eye view is the dispositive view, there are many challenges to making these assessments in advance of a judge's involvement. The judge's involvement to resolve the issue would necessitate an evidentiary hearing and further review by the appellate process, which is new territory for some circuits. The Commission staff, in preparing their impact report on this enhancement, have projected an estimated 1,452 individuals who could be affected by a retroactive application of this amendment. In POAG's view, the split between the circuits doesn't reflect a miscarriage of justice, but rather a difference of perspective with regard to whether the intent to obliterate is sufficient or success at obliteration should be the standard. A position to not make this retroactive is further supported when one considers that this application would have been applied to anyone whose firearm's serial number demonstrated scratches in an effort to render the serial number illegible, even if that effort was unsuccessful in some jurisdictions. The defendants who will benefit from the retroactive application are the ones in which they or someone else was unsuccessful in their attempt to obscure the serial number of their firearms, leaving the serial number legible to the unaided eye. While POAG is generally sympathetic towards those who are under a sentence that has been enhanced by a guideline that is no longer in effect, individuals with a firearm with an obliterated serial number and those with a firearm upon which an attempt to obliterate their serial numbers was made are not different in their intent, but only in their degree of success. POAG believes that the distinction in their degree of success at destroying a firearm's serial number does not warrant the navigation of the substantial challenges that reassessing these cases presents. Again, thank you for the opportunity to provide POAG's perspective on the retroactive considerations.
Thank you, Chair Reeves. Here, to a lesser degree, the VAG is going to make 2 points. First, again, with regard to the data. It's to a lesser degree than acquitted conduct, but we still think it's relevant that the impact analysis said, quote, it cannot determine in which of these 1452 cases the serial number might have been legible, unrecognizable to the unaided eye. We don't have that delta. We don't have the traditional information that this commission usually has, so it can understand unleashing this amendment retroactively, what kind of burden will that have? And if you don't have that information, again, it's our view that the presumption against retroactivity would control the situation. But even if you did have that, even if you do apply the information given, there's not enough basis. With regard to the magnitude of change, you simply don't know. 2 circuits applied this test. So we have no idea what this will look like in the other circuits. With regard to the difficulty in administrating the amendment, with only 2 circuits applying it, most circuits will again have to return to the evidence to apply the test. As POAG notes, even in the 2 circuits that did apply it, they had, quote, varying levels of determination. And each court, each judge will apply it differently. And this is not easy. As every stakeholder who deals with all of these cases, so the judges, the criminal law committee, DOJ, POAG, the people who deal with every single one of them, they've noted the evidence is likely to be unavailable, guns are destroyed, photos cannot be conclusive, and for all but 2 circuits, the standard will be new and will vary from court to court. And it is the VAG's view that this is going to be a clear factual determination. Is there a number that is legible to the naked eye or not? And under that, again, 3771 kicks in. And this is a hearing about the case. And therefore, we've got to have a hearing. And in the earlier panel, the statement was made, the process begins behind the scenes. The VAG would caution this commission to unleash a process that begins behind the scenes and excludes victims, when there are victims directly involved in some of these firearms cases, from any participation, as violating, if not the letter, the spirit of 3771. Turning to the purpose of the amendment, the commission said specifically the amendment resolves a circuit split. Again, this commission resolves circuit splits routinely. Guidelines are announced. Courts, well-intended courts, differ to reasonable degrees about what these words mean. The commission clarifies it. That is routine practice, not the kind of fundamental fairness amendment that sometimes has required retroactivity. And to rule differently defies Rule 4.5, and it defies the bedrock of the sentencing, which is finality and honesty in sentencing. I also want to address some of the policy considerations that the Commission has referred to in the past, and that includes the purposes of sentencing. And the concerns here are compounded by who we are dealing with. The Commission's own 2022 report, What Do Firearm Offenses Really Look Like?, is instructive on the kind of public safety implication this will have. You have said that firearm offenders sentenced under 2K 2.1, recognizing that's more broad than the specific obliterated issue that we're dealing with, have criminal histories that are more extensive and more serious than other offenders. Commission has also found firearm offenders were more than twice as likely to have a prior conviction for a violent offense compared to all other offenders. The Commission has also found the vast majority of firearms, 88%, sentenced under 2K 2.1 were prohibited from possessing firearms in the first place. And approximately 1/3 of the offenders prohibited from possessing firearms committed an offense with a stolen firearm or one with an altered or obliterated serial number. Gun violence plagues our country. It plagues particularly poor communities and communities of color. And to release such offenders out to these communities influences a racial disparity to which the Commission should pay attention to as well. And finally, with regard to the purpose of sentencing, we agree it is essential that we have consistency of sentencing, as been pointed out. But what this would do retroactively is replace one potential inconsistency of sentencing with another, because whether or not a defendant would get this reduction would not turn on what he did or who was hurt or any of the facts of the case, but it would turn on, does the gun still exist? Are the photos clear? Is the judge still alive who gave the sentence, etc.? And given the re-traumatization that victims would suffer to have these cases reopen if there is a direct victim in the crime, this just seems to replace one disparity with another, and it undermines public safety, and we would ask you not to find it retroactive. Thank you.
Thank you. Any questions? No. It's much.
Judge.
All right. Commissioner Gleason.
The beneficiaries of a retroactive application of this amendment had their sentence almost doubled. That's what 4 levels does. On the ground that they possessed a firearm with an obliterated serial number, but the serial number wasn't obliterated. We resolved a circuit split. I actually believe the difficulty of applying amendments generally, and this one specifically, can not only be overstated, but that kind of objection usually is overstated. Turns out the burden of retroactive application has always been overblown, and the participants in the system know how to deal with it. And Mr. Lurie, I'm struck by your comment that they or someone else tried to obliterate, had the intent to obliterate the serial number, both because I think it's counterfactual, and second, why anyone would think it fair if someone came into a possession of a firearm that someone else, and that's what, in my experience, usually happens. These are guns that make their way into that kind of, illegal commerce and trafficking in firearms. I don't know why you think it would be a reason not to accord retroactive application to this amendment, because someone other than the person who had his sentence doubled might have intended and then unsuccessfully attempted to obliterate a serial number. I thought what we do is we punish people for their conduct, not for other people's conduct.
I can certainly understand that, Your Honor. Having worked in a few different jurisdictions, certainly I've seen instances where people have solicited the obliteration from other people, and that has had mixed results in terms of its success. In other circumstances, perhaps the obliteration is an intended, thing that increases the value of the gun to the person receiving it even. So it's unclear. I did want to make the statement that not every defendant who has an obliterated gun is the one who obliterated it themselves or attempted to obliterate it themselves. There have been, again, in my experience, instances where they will solicit that. And so that is from other people who have the tools or the knowledge they think to do a job at that, where they themselves might not have that ability independently. And certainly, if I were holding a gun, I would be able to see whether an effort was made at that, whether it was effective, similar to the naked eye test that the judge is going through. A defendant who receives a firearm has a good sense of whether an effort was made at that, and and to what degree that effort was successful as well. So I think that they certainly are in a position still to be accountable for that firearm based on the manner in which they receive it. And certainly certain jurisdictions, there's a bit more discernment perhaps in terms of what kind of firearm they might want or the availability. But I do think that they understand what they have when they have it.
Thank you, ladies and gentlemen. I appreciate that. We're now going to take a 10-minute break, and then we'll move into our final two panels, I believe. Thank you so much. Welcome back. Our fifth panel provides us with stakeholder perspectives on retroactivity for Part B of our Circuit Conflicts Amendment. We've seen them before. First, we will hear from Adil Bashir, presenting a public defender's perspective. Ms. Manny Atwal, speaking on behalf of our TIAG, Tribal Issues Advisory Group. And third, we have Jill Bushaw speaking on behalf of POAG, our Probation Officers Advisory Group. Mr. Bashir, we're ready when you are, sir.
Thank you, and good morning once again, Commissioners. So the defenders are pleased that most of the stakeholders support retroactive application of the grouping amendment. So given the overwhelming consensus, I'll just highlight a few points that further support retroactivity. So first, the grouping amendment, like the altered serial number amendment discussed earlier today, seeks to ensure uniform application of the guidelines and avoids unwarranted sentencing disparities. The Commission has previously made similar clarifying amendments retroactive, and it should do so here to promote fairness and further the goals of just punishment and reducing disparities. And second, concerning the amendment's impact, individuals benefiting from this retroactivity are generally serving lengthy mandatory sentences with an average sentence of about 257 months. So while this commission could not determine the average extent of a reduction, even our low estimates still exceed the commission's 6-month threshold for a significant impact. So the decrease would be on par with at least some of the past retroactive guidelines amendment, most notably Part A of 821 last year. And the actual reduction could be even greater. So any way that we look at this, reducing the sentences here could have a significant impact on individuals' lives and allow them to reunite with their families and reintegrate into society sooner. And the vast majority of impacted cases involve Black men, particularly in Illinois, making retroactivity crucial for those communities. And third, as multiple stakeholders have noted, applying this amendment retroactively will be relatively straightforward. Based on the Commission's impact report, there's about 102 individuals at most that will be impacted, and experience tells us this number could probably be even smaller than that. So given available evidence, past experience, and the stakeholder support, we believe the Commission should apply this grouping amendment retroactively. Thank you.
Thank you. Good morning again. TIAG supports a retroactivity application of the grouping amendment. And as I stated earlier when discussing the Part A of the amendments, the reason being is the disparate treatment of individuals should also be the same. It doesn't matter where you are. If it's a similar crime, similar situated defendant, they should be treated the same. So therefore, as an advisory committee, we ask and encourage this commission to make grouping retroactive. Thank you.
Thank you, Chair Reeves. It is an honor once again to appear before the commission and provide testimony on behalf of the Probation Officers Advisory Group. To be fully transparent, POAG's initial discussions of this amendment favored retroactivity. Some of our initial discussions recognized that retroactivity is a rarely afforded opportunity. We discussed how it feels when we see cases presently under supervision who, because of changes in the law, would only have served a small portion of what they actually served if they were sentenced today. We asked ourselves if this was an opportunity we felt comfortable passing up, particularly in this circumstance where it is an amendment to correct an incorrect application of the grouping rules. Our discussions initially favored retroactivity because we believe this amendment would be easy to apply. After compiling the list of potentially impacted cases, determining how each case is impacted would be a rather straightforward analysis. All of the information would be clearly referenced in the pre-sentence report. We also believe the number of cases that would require fact-finding would be limited and the need for an evidentiary hearing would be rare. And for those who are deemed eligible, the process would involve a simple reconfiguration of just the grouping provisions applied in the case. Our discussions also initially favored retroactivity because the number of potentially impacted cases are manageable. The Commission has identified a mere 102 cases that would potentially be eligible. Prior experience tells us the court will receive motions for defendants who are ineligible, but we also recognize determining ineligibility would be simple and straightforward. However, after further analysis, POAG's majority vote recommended that this amendment not be made retroactive. The limited magnitude of the change and the resulting impact is a factor for our consideration. For reference, if this amendment were made retroactive for the defendant in Sinclair, the Seventh Circuit case that this amendment addresses, it would result in an offense level of 16 rather than 17. The amended guideline range for Sinclair would be 46 to 57 months rather than 51 to 63 months. Sinclair received a sentence of 57 months, which is within the overlap of either guideline range. We also believe the number of impacted cases would be nominal. We observed that the amendment would likely primarily impact the Seventh Circuit due to a 2014 appellate decision. However, fewer than the 102 identified would likely be eligible. First, approximately 48% of the cases were sentenced below the guideline range. Of those who weren't sentenced below the guideline range, POAG presumes the sentence imposed considered the 3553A factors and is reflective of the seriousness of an offense that involved using a firearm in connection with a drug trafficking offense. Second, because of the fact-specific nature of the grouping rules, the Commission was unable to determine which of those cases the grouping rules might have been applied in a manner inconsistent with the amendment, further reducing the number of cases impacted by this amendment. And finally, POAG's vote on this matter also factored in our position that retroactivity should be a careful analysis in each instance. This issue is coming up for a vote at a time when the judiciary is still processing the 2023 retroactive amendments related to status points and 0-point offenders, and the compassionate release motions that commenced as of November 2023 are maintaining an ongoing presence on the docket. POAG has given this careful consideration and observes this amendment would result in a minor adjustment on a limited number of cases. Therefore, POAG respectfully recommends that the judiciary's limited resources would best be reserved for instances where we gain the greatest impact in reducing systemic injustices and results in a more expansive and impactful outcome. Thank you.
Thank you. Any questions from our commissioners? Let's get this right. Any questions from our commissioners? I asked 3 times, so maybe 3 times is a charm. Any from this distinguished panel, to this distinguished panel? Yeah, okay. Thank you, VC Murph, for always coming through.
This is a question for Ms. Atwell, and it's kind of a dog didn't bark question. I noticed that TIAG did not take a position on the final amendment. Could you shed any light on that?
We did not, only because there was differing views, and then we just decided to kind of leave it as is.
Thanks.
Any further questions?
Well, I have one more. So one thing that POAG raised was this notion that this might be kind of a confusing amendment for defendants to figure out if they were eligible for, which I was sympathetic to because I had a hard time wrapping my head around it when we were first talking about it as an amendment. And that might lead to overfiling. Do people have thoughts on that, whether there will be a greater sort of like number of ineligible filers on this one than on some of the others, just because it is sort of complicated?
I think anytime grouping is involved, anyone could be forgiven for accusations of complications. But no, I think we're all in relative agreement that it's this is a straightforward application. And as far as just information is in the PSR, these are a discrete set of cases in an already small universe. So while and I think Chair Reeves had mentioned it earlier, anything we do here, there's going to be a good number of people that will file anyway. Since we're talking about smaller districts, smaller numbers, those factors, and I know some of the discussion earlier today too is, should we be looking at this in a vacuum or in totality? If either way that if we were looking at retroactivity and the grouping amendment, it's such a small impact overall that it would not be overburdening courts. So in terms of the overfiling concerns, I don't think any of my panelists, I don't want to speak for them, but I think we're all in agreement that it would not be in one of these overfiling situations.
Okay. Thank you. I want to thank all of you for testifying on the miscellaneous amendment. But before we move to our last panel, I just want to take a moment of personal privilege to recognize Ms. Bushaw for your service on POAG. I know that you're resigning as chair of POAG next month, and I just want to say a few words about you, if you'll allow me to. Jill Bushaw started as the 8th Circuit representative in 2016. It became clear to both the members of POAG and the commission that she was a natural-born leader. In 2017, after only a year on POAG, Ms. Bushaw became the vice chair, overseeing the editing and finalizing the position papers of POAG. After serving as vice chair for a few years, she became chair of POAG in 2020 and has done an excellent job serving in that capacity for the past 4 years. Besides being a great leader and mentor, Ms. Bushaw has ensured the POAG's public comments are always informative and include suggestions for solutions to complex issues. Just last night, as I arrived at the hotel from my long-delayed flight, I walked down to do what I do best, try to find something to eat. And who did I see? Jill Bushaw and Josh Luria with computers, papers, notepads, preparing for today's hearing. As many of you have seen, when Ms. Bushaw has testified at our public hearings, she is extremely well-prepared, well-spoken, and poised. She is always able to offer keen insight and excels at answering our questions. On behalf of the commission, and especially your fellow Iowan VC mate, Ms. Bushaw, I want to thank you for all the great work you've done as a member of POAG, and specifically for the incredible job you did as chair of POAG. And I know you're turning over the mantle to your colleague, Josh Lurie, and he'll be ready. Thank you so much for everything.
I wasn't expecting that. I tend to say I'm stepping down rather than resigning. It sounds a little bit better.
Right.
This has been an amazing experience and really the highlight of my career being part of this process, so thank you. I actually tried to get on POAG in 2011 and didn't make it, but I was thinking about this last night. I'm glad the timing of this worked out because it's been an honor, especially to be before this commission, so.
I'm glad it
appreciate all
worked
of you
out
all.
too, because I was not on the commission in 2000.
There you go. Thank you.
Barely on the court.
Yes. All right, thank you.
Thank you so much.
Appreciate it.
Our sixth and final group of panelists will provide us with the stakeholder perspectives on retroactivity for Part D, as in David, of our miscellaneous amendment. First, we will hear the Department of Justice's perspective from Paige Messick. Second, we will hear, for the last time today, I think. He's been great, though. He's been great. From Adil Bashir, presenting a public defender's perspective. Third, we will hear from Joshua Luria, presenting the Probation Officers Advisory Group's perspective. And finally, rounding out for us today is Ms. Professor Leary, presenting the Victims Advisory Group's perspective. Ms. Messick, we'll start with you, and we're ready when you are.
Thank you again, Chair Reeves, for the opportunity to share the views of the Department of Justice. The department, as you know, opposes retroactivity of the 2D 1.1 amendment. We recognize that the pool of eligible individuals is relatively small in comparison to some of the other amendments under consideration today. Some of the 538 cases in the Commission's identified group will have stipulations, so the number of eligible individuals will be smaller than that. Of course, that doesn't mean that the number of motions filed will be smaller than that. And while the government and the courts have developed processes in response to last year's and other amendments, these motions still take time and finite resources away from other pressing needs. It's one thing to devote those resources to revisiting closed cases when a retroactive amendment is necessary to avoid true injustice. But on the whole, these aren't cases that cry out for redress. The sentencing courts in these cases have already carefully considered the offense conduct and the 3553A factors. And in nearly 60% of the identified cases, they have already imposed a sentence below the guideline range. In many and perhaps most of these cases, you can expect to find a defendant who has received a sizable benefit from a prosecutor's decision not to pursue a lengthy mandatory minimum sentence, and to instead rely on the guidelines to take account of the harm caused by that defendant's conduct. In cases where the government could have proven the death or serious bodily injury beyond a reasonable doubt in the absence of a guidelines option, retroactivity will result in windfalls that undermine the public trust in the criminal justice system and in the guidelines in particular. Retroactivity may also unintentionally encourage prosecutors to bring more mandatory minimum charges because of a growing sense that guideline sentences lack finality. There are practical challenges as well. To be sure, the factual questions here wouldn't be as difficult as with the acquitted conduct or the firearms amendments. But it won't always be easy to calculate the reduced guideline range under the amendment, and that could bring the possibility of a second windfall to some defendants. This is because the PSRs won't necessarily have the information needed to make a brand new quantity determination. Looking to the current guidelines manual, no defendant who received a base offense level of 38 or 43 under A1 or 2 could have done any better with a quantity-based guideline calculation, given that the quantity table tops out at 38. So the PSRs in these cases may not contain quantity calculations, especially in multi-defendant cases where that assessment can be quite difficult. Where the evidence is no longer available or where a court lacks the option to take new evidence, the defendant will be held accountable for a drug quantity that was lower than the one that would once have been provable. And just as in the serial number context, these gaps in the record will open the door to results that differ not on the facts of the cases, but the happenstance of the level of detail present in the existing record. We can't forget that every one of these cases will involve someone whose drug offense caused death or serious bodily injury. The family members of deceased victims, in particular, shouldn't be put through the pain of reopening these sentences. This is particularly true because the Commission has not adopted any new guideline provision to take account of the death or serious bodily injury. We'll have to tell victims that even though the defendant was sentenced under a reasonable interpretation of the guidelines, and even though the defendant benefited from a prosecutor's decision not to pursue a mandatory minimum, the defendant now has an opportunity to be resentenced to a much shorter term under a system that takes no formal account of the death of their loved one. That's a hard thing to explain to a grieving family. For these reasons and others, the Commission received comment from a number of sitting judges who recognize that retroactivity is sometimes appropriate and who nevertheless oppose taking that path here. These are not people allergic to work, but they see that with this amendment, the balance doesn't favor retroactivity. Making this amendment retroactive would upend resolutions reached in good faith, divert resources from other pressing needs, create new disparities, and put victims through the trauma of proceedings that they thought for good reason were closed. For these reasons, the Department asks that the Commission not make this amendment retroactive.
Thank you, Mr. Bashir.
Good almost afternoon, commissioners. The defenders support the retroactive application of the enhanced base offense level amendment to 2D 1.1. And I want to start by acknowledging the devastating impact of the opioid epidemic and drug overdose deaths on victims, their families, and communities. Many of our clients charged in these cases were themselves selling to support a paralyzing drug habit. We empathize with the victims, their families, and this issue is personal for us and our clients as well. But it is precisely because of this empathy, defenders believe retroactivity is warranted. And I want to focus my comments on three primary reasons to make this amendment retroactive. First, as the reason for amendment shows, the enhanced base offense levels are meant for individuals statutorily linked to a death or substantial injury, consistent with Supreme Court case law. And in my experience, both working in trials and over a decade of doing appeals in the 11th Circuit, when the government has evidence to meet the beyond a reasonable doubt standard in a death resulting case, they typically charge the aggravated statutory offense. Now, I'm aware of cases where the government declines to charge the mandatory minimum but reached a stipulation agreement with the defense to apply base offense levels for death resulting. And of course, this amendment will not affect these two groups of people that we're talking about. So what we have left is a third small group of people who are not charged with a mandatory minimum and did not stipulate to the enhanced base offense level, but had those enhanced base offense levels applied anyway. And retroactivity would merely open the door for this small subset of people who are enhanced based on a low burden of proof with evidence that might not have met that higher burden of beyond a reasonable doubt to make their case for reduction. And while the Commission will open this door, it certainly will not walk anyone through it. And the sentencing judge is the ultimate decider. And where a reduced sentence is not proper and does not reflect the purpose of sentencing, a judge need not grant it. And 3582C2 has built-in backstops to make sure those that are undeserving of a reduction do not get it. Second, the purpose of the amendment and the magnitude of the change strongly favor retroactivity. The amendment promotes fair, uniform guideline application and proportional punishment. These are all important goals of sentencing and the guideline system as a whole. And we expect the magnitude to be substantial in some of these cases that favor retroactivity. And we know these enhanced base offense levels can lead to extremely high sentences, in some cases all the way from 30 years to life. In other words, the sentences our clients are receiving for selling drugs can be higher than homicide sentences in state court. And understandably, such sentences for nonviolent drug crimes can shock the conscious, promoting disrespect for the law. And apart from the disparity between the charged offense and the guideline range, retroactivity would redress the disparities caused by some courts' misinterpretation of the provision and alleviate some well-documented racial disparities, as our written comment notes. And third, and this is, I think, the most fundamental point I can make, making this amendment retroactive would not undermine public safety. As our experience with the war on drugs and numerous other studies have shown, lengthy sentences do not deter drug selling or use. Where there's a demand, unfortunately, there's been a supply. regardless of the draconian drug penalties for over the last 40 years. Nor do they curb overdose deaths. That's why experts suggest focusing our energy on prevention, treatment, public education, social investment, and other strategies other than the tough-on-crime approach to use drug selling. And when suppliers certainly must be held accountable, and we do not diminish that at all, inordinately high sentences in drug cases misplace some of that blame. The disease of addiction, of course, is partly to blame. Families who've lost loved ones to the disease of addiction have even acknowledged this reality, speaking out publicly against drug-induced homicide laws. So the commission really should exercise its authority and make this amendment retroactive. This is once again, a small subset of individuals that may not have had their culpability linked to the enhanced base offense levels that they face. We can do so efficiently, and courts have the ability to ensure those who are worthy of a reduction will receive it. Thank you.
Thank you. Mr. Luria.
Still morning, so definitely good morning.
Still more.
Thank you for the opportunity to provide POAG's thoughts on the prospect of the retroactive application of the upcoming change to Section 2D 1.1, A1 through 4. After discussion, POAG unanimously supports the retroactive application of this guideline. As noted in our previous testimony about the amendment and our written testimony on retroactivity, the difference between a defendant who has a base offense level under Section 2D 1.1, A1 through 4, and the same defendant who had a base offense level based on a quantity can be substantial. In March, during our testimony, we outlined how a person could have had a base offense level of 38 under Section 2D 1.1 A2 versus a base offense level of 12 based on the quantity of drugs involved. That is a substantial difference, one that likely had an incredible impact on the defendant's liberty. The language change provides clarity about what the Commission intended regarding this base offense level. Retroactivity in this instance would allow for the review of sentences that had misinterpreted those base offense levels, correcting those substantially higher sentences. Unlike some of the other retroactivity initiatives that are being considered, this one should also be generally easy to analyze. The relevant conduct in these cases will likely have the quantity involved, even if it is not the fact that is relied upon to create the base offense level. The statutory penalties should be outlined in every pre-sentence report. The stipulations, if applicable, should be clear within the record. The quantity has either been figured out or the lack of quantity is discernible and can be calculated upon. POAG has concerns that there may be an impact to the victim's sense of justice. However, we believe that judges will be able to balance the victim's interests within their discretion. Victims or their families were given an opportunity to be heard during the process of the initial sentencing, and their statements will also likely be in the record available for consideration. This is an opportunity to correct something that was incorrectly applied, and the difference in outcomes is staggering. While POAG has observed that the judiciary is still processing the retroactive initiatives from 2023, POAG believes that this has a large impact and is too great an opportunity to pass up. The analysis on it is relatively easy, with little or no additional investigative efforts. We previously testified today that the judiciary's limited resources would best be reserved for instances where we gain the greatest impact in reducing systemic injustices. These are those cases, and this is the area where we can have a significant impact. Thank you.
Thank you. In reviewing the written comments on this particular amendment, a lot was said about two words, certainty and fairness. And so the VAG wants to focus on those two words. What is certain in this scenario? Death. Death is certain. Or serious bodily injury, which is defined not something minor, but a protracted impairment of a function of a bodily member or organ requiring medical intervention such as surgery or hospitalization. Those are certain, those are final, those are permanent. What is also certain, or is supposed to be certain, is a sentence that a victim or the family of a decedent hears when they're in court, and the judge looks over from the bench to everyone in the courtroom and says, this sentence is final. We have honesty in sentencing in America. And so to change the sentence now violates all the factors the Commission must consider in retroactivity, and it would create certain unfair and permanent retrauma for victims and their families. This panel is entitled the Stakeholder Panel, and we were happy to see that on the VAG because we're not normally on that panel, because we're not normally recognized outside of the Commission as stakeholders. But it's important to recognize that while the VAG appreciates passing recognition victims may go through a few things, in this context, and again, let me be clear, the Commission always recognizes us as stakeholders, other stakeholders less so. In the courtroom, the only stakeholder that did nothing to get in there is the victim, plucked from their lives, their everyday lives, re-traumatized by a crime, re-traumatized by a trial, re-traumatized by a sentence, and now re-traumatized by finding out later, because they won't get notice of this, or they won't be present at a hearing, that the fact that their loved one was killed simply doesn't matter anymore, because we're applying different rules. And the VAG would submit that that is both unfair and undermines the certainty of sentencing. And many, and well, we appreciate the anecdotal experience of many who've testified today. The anecdotal experience of the VAG, who are victim advocates and lawyers from across the country, has been this. When does this typically come up? A prosecutor has a situation in which there's a drug charge and there's a death, and what to do. And in most of those cases, the prosecutor, in the cases we're talking about, the prosecutor has foregone charging the mandatory minimum offense. Instead, operating under the rules that afford him, uses his or her discretion to proceed in a way that will accurately reflect the gravity of the harm, but not the mandatory minimum in which he may feel is too harsh. And it is not the experience of the VAG that that is only when the prosecutor cannot prove the mandatory minimum. So the offender receives that windfall, the victim survivor witnesses it. And now, to apply this retroactively would be a tremendous windfall. To sua sponte, change the rules, not prospectively, where again, the victim then could consult with the prosecutor and we could be looking forward to what tools are available now. But retroactively, that is not a just verdict. And as the Department of Justice has described this, the magnitude would drop dramatically. To the VAG, frankly, the magnitude of this change would be unforgivable. That sentence was the result of a prosecutor using their discretion not to charge a mandatory minimum. And importantly, on top of that, in 46.9% of these cases, the judges then sentenced below the guidelines, windfall number 2. And now, under new rules applied to an old case, the result will be to simply strip away the actual harm that was caused, the death or serious bodily injury, and create what we would argue is a fictional sentence, a sentence that reflects not in fact what happened, but half of what happened. That does not speak to the purpose of this amendment, which this commission has said is not about fairness, but to clarify an ambiguity. And it doesn't speak to the purposes of sentencing. The commission would simply highlight the words of the Criminal Law Committee, speaking to caution about a trend toward applying an amendment retroactively, quote, even where the amendment does not rectify fundamental inequity or unfairness. Over time, the guidelines will be seen as fundamentally unfair, undermining confidence in the system. And lastly, just a response to the point about public safety. Make no mistake about it, this will create a public safety problem. Your own statistics show us that when people serve a longer sentence, their instances of recommitting rearrests actually go down. So this will have an implication on the situation that the country is experiencing, the crisis of opioid deaths. And while we appreciate acknowledge to it, the statistics actually suggest that going retroactive would hurt the efforts in that area, and again, affect, unfortunately, again, the same communities that often are affected, marginalized communities, people of color, and people who are poor. And the VAG adamantly opposes this kind of a retroactive application. Thank you.
Thank you, Ms. Leary. Panelists, commissioners. Any questions? Commissioner Gleason.
Yeah, I have three comments on the department's position, I think all of which transcend this immediate context, but I thought I'd share them for what they're worth. One is we've heard it several times this morning that one reason not to accord retroactive effect to guidelines would be judges have already considered all these facts and all these factors and imposed sentence, and may even have imposed a sentence below the range. And I think that ignores a reality. I think if we've learned nothing in the last couple of decades is there's a striking anchoring effect to the guideline ranges. And judges may have already considered all the factors, but there's every reason to think if the range goes lower, the sentence will go lower. Second, I don't know about this windfall business. I don't think when judges reduce a sentence, they have the discretion to reduce. It translates into ignoring grieving families or some kind of windfall. I think presumptively that's the result of judges dishing out justice. And if they get it wrong, that's why we have courts of appeals, to fix it. So I resist the idea that judges exercising discretion that they receive when there's a retroactive guideline amendment is some kind of windfall. I think that derogates the significance of what judges do. And lastly, this idea that if you can't persuade judges to do what the DOJ wants, then that runs the risk that DOJ will treat defendants more harshly because, as the department put it, prosecutors won't trust the finality of a guideline sentence. And I can't, we're supposed to do what's right, what we think is right. And if the result of that is prosecutors will exercise their discretion to invoke mandatory minimums because they can't persuade judges to do the judging that they think is right, that's a problem, I agree. But it's not a reason for us not to do what's right. It's a reason for us to maybe comment on how prosecutors are deploying their discretion. But I don't see how we avoid making what we think is the right decision from a sentencing policy standpoint, because a DOJ has told us, watch out, we got these man-mins, and we're going to start whipping them out to correct the effects of judgments that you think are fair.
I have responses. I'll go in order. On the first point about the anchoring effect of the guidelines, and judges have already considered 3553A, but we also know that sometimes they do make changes right after amendments have become retroactive, even though they've already considered all of these things. We don't dispute that the guidelines do have that anchoring effect. But here, I think what's missing from the picture is that the alternative, the sort of fictional setting, if these amendments had been in place at the time, is not necessarily just a defendant getting sentenced under a much lower guideline level. You could have a defendant who instead is facing a mandatory minimum, or you could have a defendant who instead is, if we'd actually had this provision in place that has a reference to stipulations, you would probably see more defendants sentenced with stipulations. So these prosecutors have already been lenient in two ways. They have not required the defendant to face a mandatory minimum charge, and they've also given a chance to the defendant who doesn't believe that this enhancement is appropriate to beat it on the facts. They haven't required a stipulation in order to forego that mandatory minimum sentence. And so I don't think that the proper point of comparison is necessarily just what would have happened if the guideline range had been lower, because we just don't know that that would actually have been what would have happened. And in a lot of these cases, I submit it wouldn't have been. On the second point about windfalls, I just want to be clear what we are referring to when we say windfall. It's not just getting a lower sentence under a lower guideline range. It's the idea that a defendant would receive a lower sentence than he or she would have received at sentencing had these amendments been in effect at the time. And that can take at least two forms here, because the defendant has avoided a mandatory minimum that he or she may otherwise have faced. So they actually be getting a lower sentence than they would have had these provisions been in effect, or they have avoided a stipulation, as I mentioned before, or in cases where the record is unclear and we can no longer establish drug quantity, they may be getting a much lower guideline offense level than they really should if all of the evidence had been presented at sentencing, which if these guideline amendments had been in effect and we were looking for a lower offense level, we would have had that kind of evidence at the time. So the idea of the windfall is that a defendant is doing better than he or she would have done had these amendments actually been in effect. It's the third point that the commission shouldn't take into account, the idea that prosecutors may turn to more mandatory minimum sentences because of the sense that the guideline sentences aren't final anymore. I do think that this is a risk that you could see more mandatory minimum sentences here, and not because we think that those are more than is, it's not us thinking that these are more than is necessary to deliver justice, but when the alternative is to have somebody sentenced under a system that takes no formal account of the death of a person or their serious bodily injury, a prosecutor may say, if that's my alternative, it actually is a mandatory minimum that delivers a more just sentence. And we're also looking in this assessment of what the just outcome is to interests of finality and to bringing closure to victims. And if we know that it's fairly likely that sometime down the road there's going to be another amendment that affects the guideline sentence that a defendant would have received under a non-mandatory minimum sentence, I do think you may see prosecutors fairly in their discretion determining that these mandatory minimums actually are the way to deliver a more just result. So I do think that the commission should take that into account.
Any additional questions? Ms. Wong, and I see Commissioner Mosley as well.
I just think it would
Commissioner
be,
Wong.
as we talk about how the universe of people that could go from 38 to 12, I think it would be helpful to flesh out what some of the practical, in a concrete way, what types of people were previously receiving 38 that would now receive 12. And would you agree with me that one scenario would be there's a plea negotiation, and it could be a defendant that does not want to agree in the statement of facts that they caused the death, but that the government permitted sort of a agree to disagree plea offer where the statement of facts, the stipulated facts, did not entail the death or serious bodily injury, and then at sentencing, evidence was presented, and that was left for the judge to determine it. And in the situation where they received 38, that would be because this was not agreed to by the parties, but the judge found that death or serious bodily injury resulted. Is that what we're talking about concretely? That's the scenario? There's no stipulation, so they wouldn't now get 38, but a judge found that death or serious bodily injury?
So, I'm sorry, I didn't mean to jump in. So I think part of that is correct, but I think the question is actually spot on, because we really should look at the practicality of what we're dealing with. And where I think perhaps that scenario occurs, but I can tell you from my experience and the way that the way plea negotiation, particularly in a post-barrage, death results type of world, there's leverage points that we have to account for. So the type of plea that you're speaking of typically occurs of where if I'm in a position representing a defendant and we do not want to stipulate to a death, it's because that evidence does not exist, or it's not conclusive, or it's not particularly there. It may be there for the guidelines enhancement, but it's not we're talking about a different level of culpability. And where you have a prosecutor who would agree to such a plea agreement and say, let's go to a judge, these are the situations, and we're talking about a small group of people that have at least a different culpability than people that have been conclusively linked to death. And so when we're talking about the types of people that are at least getting the opportunity to put forth an argument to say, I was sentenced based as if I had been conclusively proven to have caused a death or stipulated to such, but in fact, that is not true, that's the only group of people that not only would be arguably eligible, that are really going to be benefiting. All these situations of downward variances or upward variances, or where a judge has found by preponderance of the evidence that there is sufficient facts, these are not the situation, and these are not the cases of where anyone, even if they're technically eligible, are going to be receiving discretionary relief. So practically speaking, the group of people, and I think we agree with the probation office here as well, is it's a very small group of people that were given a significant sentence as if their culpability was for something that was much greater than what could actually have been proven in their case.
Sorry, can I just follow up on that, though? But if they previously got 38, and they would no longer, post-amendment, get 38, to have previously gotten 38, a judge would have found, based on the evidence, that there was death or serious bodily injury, notwithstanding a lack of stipulation, right?
Yes, that's my understanding and experience with it as well. And a lot of these cases that in our discussions about this, a lot of these cases where it's a 38 to 12 kind of jump are these kind of early fentanyl causing death circumstances, as friend-to-friend transactions of very low quantities, oftentimes grams, small amounts of, that's why it's the 2D1.1C14, because it's 4 grams or less. And, the stipulations, oftentimes there'll be stipulations about the causing of death because they know there's only one substance and that friend gave it to them. Even if there's not stipulations, it's sometimes just a result of them not wanting to say outright that they caused the death of their friend. And there's a lot of emotion about it because of, it could have been them who got killed based on whichever hand they happened to hand the drugs off to. There's a lot of guilt about it because they knew that person for a long time. There's a lot of factors that go into it. Those 3812s being kind of that frontline case, low quantity, but likely high stipulation to the fact that that is the cause of it, but not a stipulation that would have accounted for it under a 1B1.2A structuring.
It seems to me that if that's the comparator between people who are where the parties agree to stipulate to that versus where the parties agree to litigate it before the court and have the judge find it, that the question is whether that's really a matter of fundamental fairness between those two groups, that somebody who received that same offense level as a stipulation but allowed the judge to find it is really now in a fundamentally unfair position because that judge found finding is somehow so inferior to the stipulation. And I guess I just wonder if that's how I'm sort of conceptualizing this. Is that matter of fundamental unfairness that previously either a judge's finding as to death and serious bodily injury was treated as equivalent to a party stipulation in terms of ultimate computation of the offense guideline? Was that person so penalized by the previous, by that previous misunderstanding?
It's unclear, but I think certainly starting at 38 versus 12 is a substantial difference in terms of just a starting point in the thought process of where a range should be. In these types of situations, sometimes the stipulations were thought to be sufficient to meet a 1B1.2A structuring, but they lack that additional element of it's our intention that this be something that guides the guidelines, that drives the guidelines, because it's a higher crime than the offense of conviction. And that stipulation isn't necessary, that second stipulation isn't necessarily there. And that's where the error really is. It's saying, hey, I likely caused the death of my friend or the victim. And they don't necessarily take the next step and say, and I agree that I should be held accountable at that higher level 38. That second stipulation is missing in a lot of these cases, which is why it's a misapplication.
And if I can just add one quick sentence to that, and also because of the evidentiary differences as well, which would make the distinction between your conviction and your stipulation versus even in these litigation contexts. So the delta really there is a fundamental unfairness that should at least be allowed, the judge should be allowed to go back and look at those for retroactive application.
That's less clear to us, at least, because the prosecutorial discretion within that, certainly there's a lot of elements taken into account versus getting a minimum mandatory on a case like this, versus allowing the judge the discretion to determine where they want this defendant specifically to end up. So I don't necessarily, I'm not certain about how closely I would follow that, just based also on what the DOJ was saying earlier today, too. So, but I do think that it's certainly a different circumstance.
Commissioner Meisler?
From Mr. Luria, just an empirical question. I thought I understood your testimony today to be that POAG was not so concerned about the recalculation of the new range, right? Basically the 12, because you thought that even in cases where it was clear or was litigated that the higher offense level would apply because of the death or serious injury, the amount of drugs would be in the PSR. So, is that right?
Yes. So I heard earlier that there was about 30 amendments that have gone retroactive. Many of those have been drug amendments, and the system has learned really well to make sure that we have quantities very clearly delineated within relevant conduct, not only for if retroactivity occurs for clarity's sake, but also to really appropriately capture along that metric the severity of the circumstances. So almost uniformly, I think you might find some outliers where there's not quantity, and those would really be outliers. Majority of pre-sentence reports that are out there in the last 15 years or so are going to have quantities ascribed within them, regardless of whether that quantity is used as a base offense level or not.
Thank you.
Commissioner Mate?
I have just one more question, and this could go to several different people. But my understanding of sort of the where this amendment came from was about the prior convictions and the filing of 851s. And that, so there's not everyone who's going to be going from a 38 to a 12 on this. Someone could be dropping to still an enhanced base offense level, not just to the drug quantities, if what's missing is about the prior conviction. So leaving aside the death resulting piece. Am I correct about that in terms of that movement, that it wouldn't always be to the drug quantity base offense level?
I think it's hard for us to see exactly which cases that would be most impacted. But based on our discussion, it seemed like these frontline cases would be the ones that would be most impacted and probably have the most of those because of that initial error in the way that language was initially read. That these ones are the ones that would probably be the most impacted by that.
Okay.
I think, I was going to say, I think it's a similar assessment. And I think the major point would be that whatever the reduction is going to be is going to be substantial based on where we're starting at these 38s.
And one kind of related question, going back to kind of the way the amendment was structured, the reason the stipulation piece even came in, as we were hearing, it was a current practice, and please continue this in the amendment. So in terms of the number of cases that likely wouldn't have those stipulations, does anyone have a sense of how common that stipulation practice was and what?
I can say in dealing with our defender working groups across the country, and many districts use the stipulation practice. We've reviewed a number of plea agreements. Almost all of them have the stipulation language within it. So we're really, again, talking about a very small universe of people because the practice, again, when the evidentiary proof is there or a negotiation otherwise, you would either have the mandatory minimum or you would have the stipulation in there.
I do think that we'll find a lot of stipulations in these cases, but it's really hard for us to put a number on that, or even really a good estimate, because it's just been hard to identify which cases are potentially eligible. You know, we try to sort of pull the same kind of information that we were able to find for the firearms amendments, and it just was much more difficult to lay our hands on concrete examples. And so, you know, I could say, well, you know, based on 12 cases I looked at, there, you know, 6 of them had stipulations, but it just seems in this context, we don't, as a whole, have a great sense of what these cases actually look like. Are they, you know, 38s going down to 12s? Do they have sort of higher backstops? I think we don't, as a group, have a great sense of the particulars.
If I could just jump in to say, listening to all the answers seem to be, we just don't know a lot of the time. And if we just don't know a lot of the time under 4.1a, that's why the amendments are presumed to be only prospective, not retroactive. Because if we don't know, the commission shouldn't be pursuing it that way. And in this instance, we don't know because, well, we might be able to identify the numbers. It's so fact-specific. And from a victim perspective, I just want to add in all of these negotiations and discussions, victims' rights have been honored. They've been able to contribute to these conversations. And as Mr. Loria pointed out, often they too know the offender, right, et cetera. They're part of that. To go retroactive now without knowing the answer to any of these questions eliminates that, because they won't be a part of these future sentences. And so from the VAG perspective, not knowing all these answers is why the rules require an impact analysis, and the rules require you to think of this prospectively only and provide a relatively narrow path to look backwards to see if that is, quote unquote, the right thing to do. And it can't be the right thing to do if we don't know the answers.
Thank you. I don't see any of the commissioners jumping at bit for another question, but with that, I'd like to bring our hearing on retroactivity to an end. On behalf of my fellow commissioners, I want to again thank our panelists. Thank you for your service. I also want to thank our staff and all those who've taken the time to listen in. We have heard your testimony. We will consider your testimony. Our work continues. We will use that testimony to make sentencing policy that is right, that is fair, and that is just. One final note about our continuing work. The Commission has reached out to judges, stakeholders, and the public at large, and asked them to advise us on our ongoing work. There is still time left to do so. Please let us hear from you. We've heard from a lot of you, but let us hear from you by 5:00 p.m. Eastern Standard or Eastern Daylight Time. 5:00 today. Huh? Our work continues. And on a final note, before I adjourn, I want to wish our colleague a happy birthday from yesterday, Commissioner Gleason. So with that, with respect to this hearing, thank you, ladies and gentlemen. It is now adjourned.